The consent of the other side lordship, I beg to mention about 3 lots.
Yes.
In this case, B. Majumdar is appearing lordship. He has some personal difficulties.
15 matter.
Can I take next Tuesday, Lord?
15 matter. Why do you seek for time? We don't grant adjournment of 15 matters. If 15 next Tuesday for disposal.
Lots.
Oh, other side SP Roy. Have you informed him?
Yes.
Next Tuesday for disposal. We are not going to adjourn this matter. Maybe whoever is the.
Lots.
Okay. A prayer for adjournment has been made on behalf of D. Majumdar Learned AAG Assam. Para. Considering that this writ petition is of the year 2015, a slight accommodation is given directing listing of this matter on Tuesday for admission hearing. Tuesday, huh? 26. Yes.
Net this one. But I think was 16 mile have today today. We have filed on affidavit in reply to us. We take mile.
I have filed a fresh writ petition. Can it be taken up tomorrow? Eviction matter.
A motion.
May I please, your lordship? My lord, I beg to mention today's, my lord, item number 54 to 57 listed in the supplementary. My lord,
yes.
that eviction matters, my lord.
Yes.
My lord, may I pray that this matter may be kindly be taken up on next week Tuesday, my lord, with the consent of all the parties, my lord.
Next Tuesday, we have already fixed. We'll be on Thursday.
Thursday, my lord. Thursday.
Tuesday, many matters have been fixed. Thursday is okay?
My lord. My lord, interim orders may kindly be continued, my lord.
Yes. A request for accommodation has been made on behalf of the petitioners. Para. Sri Borpujari, our Borpujari Standing Council Revenue has however expressed urgency as there is an interim order operating. Para. Considering the same, matters are adjourned to be listed on Thursday next.
Lord, I have been informed, we are led by learned senior counsel, Mr. Ken Chaudhary, my lord. He
So
has-
27th?
My
27th.
lord.
On 27th.
Obliged, my lord.
27th. So interim order passed earlier to continue till the next date of listing.
My lord. Highly obliged, my lord.
This will be 54, 55?
Up to 57, my lord.
57, okay.
My lord.
57,
My lord.
whole matter.
Wait, please, Your Lordship. My lord, on repetition, lordship, we filed application for registration of marriage under Special Marriage Act, lordship.
Motion or what?
No, lordship, for order, lordship. Government has filed affidavit, lordship.
Order, matter of which year?
Matter of this year, lordship, but as marriage,
Sorry, no
marriage
urgency.
is pending, lordship.
No urgency. No out of turn listing. Get it listed in the registry. Mention memos are only for extreme urgency. Yes.
Marriage is
Lordship, with
pending.
due consent of the other side, I beg to mention item number 10, Your Lordship. I have received my instructions in this particular case, my lord. I'll be filing my affidavit, my lord. I've taken the consent of the other side.
Item number 10.
10, my lord. My lord, the matter may be fixed after 2 weeks, my lord. I'll be preparing it and be sending it and.
You're for whom?
I'm for the elementary education department.
Okay.
I'm for the petitioner, my lord.
He's for the petitioner, my lord.
Sri A. Fukan, Learned Standing Council, Elementary Education, has submitted that instructions have been received and the affidavit in opposition would be filed shortly. Where he accordingly prays for and is granted 2 weeks time.
2 weeks, my lord.
2 weeks time.
That may be.
List after 2 weeks.
Deeply obliged, my lord. Deeply obliged.
Yes.
May it please, my lord. My lord, I beg to make a prayer for listing for the purpose of withdrawal, my lord. Can it be listed tomorrow? Deeply obliged.
May I please, Your Lordship, my lord? In item number 17 and 23, my lord, we file and my lord affidavit in reply, my lord, affidavit filed. So there is composite affidavit has been filed by the government.
Okay, today you have filed.
No, my lord. Yes, sir, we have filed,
It is not with the records.
not the government. And one today. has been-
Today,
No. See,
Lordship has already permitted the affidavit which has been filed today to be brought on record, and 2 affidavits have been filed yesterday. Then also.
No, those will be in records, but these were listed with the purpose, with the intent that we take it up.
My lord.
If the affidavits, okay, bring it, let us see.
yes.
We may not have a hearing today, may not be possible. Let first bring it, we are not saying
Yes, sir.
anything. First bring it.
May it please, your lordship. Lordship, I beg to mention item number 48. I have taken consent for others.
14.
48, lordship.
40.
48, lordship.
48.
Lordship.
Yes.
I have taken consent of the petitioner side, lordship.
Hmm.
Matter may pass over for the day only, lordship.
Why 15 matter?
Lordship, conducting counsel, Mr. T.S. Hajarga is out of station, Lordship.
15 matter, we don't adjourn like this.
Accommodation-
Right to hearing. 1 decade writ petition. Does it look good?
He is out of station. For the
It's a writ petition, not even a civil case. 10 years.
in any day on next week, Lordship.
Let it reach. We are not going to adjourn matters of 2015.
Lordship, we figure on day after tomorrow, Lordship.
We are not going to adjourn. Let it reach. We'll see. Yes,
Please, Your Lordship. Lordship, I pray for
Obliged.
listing contempt petition any date of next week.
fresh
For
matter.
orders, Your Lordship.
Orders, contempt, what urgency?
Because Your Lordship, both the respondent side already filed lokalat. So matter since pending.
By out of turn hearing, by a mention memo. It will be listed on its own. No mention memo.
Obliged, sir.
Lordship, similar matters are notice was issued, what to let it be take because the matter has been referred to the a nodal officer, Lordship. This is the order, Lordship. Similar matter notice has been issued
What is Hewa Setu? Hewa Setu is for what?
because his error, some errors are showing when they filed the appeal, Lordship. It has
This
sale
online
permission, sale permission.
sale permission.
Sale
Okay.
Similar petition, same.
Okay, we'll issue notice at this
Yes.
stage. What is your name?
R.A. Majumdar.
R.A. Mazumdar, heard 3 R.A. Mazumdar, learned counsel for the petitioner who is aggrieved that the application submitted for grant of NOC through the Seva Setu inverted comma has not been decided within the prescribed time as per the Assam Right to Public Services Act 2012. Full stop. Para, when this matter was taken up on 23/7/2025, the Learned State Council was directed to take instructions. Full stop. Para. Let notice be issued, returnable by 4 weeks. Petitioner আছে দুটা আছে Revenue Department, Madam. G. Hazarika 1. Then
And for
SS
two-
Roy State Council 2,
3, 4 and 5.
4 and 5. Extra copies I think already given.
Lordship.
List along with WPC 4208 of 2025, which is said to be on a similar issue.
On 15th.
That is fixed on 15.
Yes, Your Lord.
Along with we have said.
Lordship.
Obliged.
Lordship, in item number 2, Lordship, we have filed an IA Lordship, another IA Lordship. We filed it yesterday, Lordship. The filing number is 10705, Lordship.
IA is for?
We have brought on record a subsequent development, Your Lordship.
No, IA is not for development. For that you file an affidavit. IA is for, it has some prayer. What
So
is
we
your
have
prayer?
prayed, Lordship, to quash a particular order, Your Lordship.
Not one order has been passed by the GMD authority cancelling his land sale permission.
Cancelling his
Land sale permission. It was.
land sale permit?
Yes, it was issued by the GMD authority, subsequently it has been
Cancelled.
cancelled. He has challenged that cancellation in an IA.
Oh, that perhaps will not do.
So what I would pray, Lordship, that both these matters can come up together on Friday, Your Lordship.
It pertains to unauthorized construction, Lordship. Demolition order was issued in the year 2023 itself.
Okay.
Yes, it's continuing like that, Lordship.
Okay, no, we'll not grant so much
No, I
of
have
time.
filed one vacating also, Lord.
Okay. Okay, day after tomorrow.
Lordship, may kindly, day after tomorrow, I may not be here.
Then
On-
tell us.
On 27th, Lordship, Tuesday.
26 seconds.
27th, yes, Wednesday we can do.
27.
This court has been informed that the writ petitioner has filed another IA, which however has not been listed. List these cases along with the IA said to have been filed on,
Yesterday, Lordship, I'm giving the filing number, Your Lordship.
filed yesterday. That is, so with filing number
10705.
1707
107, Lordship.
107
05
10705
of 2025.
of 2025.
Lordship.
Pick on last line too. with filing number so on 27th.
Yes.
There's the interim order operating lordship.
Interim order passed earlier to continue till the next date of listing.
Lordship.
You could take it or leave it. No, এটাই order for read petition ISO. Yes, next. Yes, madam.
My lord, the matter is ready, but I respectfully request a short passover for a time being. My senior is coming.
Who is your senior?
I Chaudhary, Advocate I Chaudhary.
Okay, we'll wait for a while.
Yes.
Other side, revenue. Okay. What is the matter?
Compensation not paid.
Compensation not paid. You file your affidavit.
Yes, your lordship.
R4 has filed, R2 has also filed.
Provision.
These are disputes, factual disputes.
Factual dispute.
It's apportionment of compensation for land acquisition. His name was not there.
And
He
the
says that there was a mutation order by which his name was deleted. Now he's aggrieved by that.
the records are also
Who
missing.
is for the private respondent? Madam? Who is for the private respondent?
D Deca appears.
Private respondent number 7.
Yes,
7 is represented by
D Deca.
D. Deca. Where is Mr. D. Deca? Okay, after a while. May not be a case for which requires interference by writ court. Let us see. Yes.
I didn't find.
Item 5, yes.
Non-payment, your lordship.
Hmm?
Non-payment of contractors bill, your lordship.
Is it bench 5 matter?
No, your lordship, bench 4 matter.
Bench 4, let it go before the appropriate bench. Let before the appropriate bench.
Public.
Okay.
Appropriate bench.
My pleasure, lordship. Well, the petitioner has challenged the illegal eviction. Illegal eviction from the land. Well, the petitioner is in occupation of a
The
land
eviction is done by whom?
municipality,
Which municipality?
Nagaon municipality.
Nagaon.
Nagaon municipality is not the owner of the land, it is the state government. Now, how the municipality can evict me from the land?
You are for the Nagaon municipality?
Yes, madam.
You filed your response.
Yes.
I have already filed.
What did you file? Okay, you can argue, yes.
Well, the petitioner is a businessman. He is occupying a land measuring 15 acres under the Nagaon. And he applied for the TOSI register of his name before the deputy commissioner. That petition was pending. Sometime the municipality issued a
So what is
notice.
the status of the land? Land which is under your possession?
It is a government land.
Government land. Khas land.
Yes, khas land.
Okay.
We made a prayer before the authority to register my name in the TOG register. That petitions were pending. And when I am occupying the land and my business also is therein, the municipality alleged to be issued a notice directing me to leave the land. And that notice was issued to me showing the DAG number is 8011, whereas I am possessing the land of 811.
And what is the notice of the this eviction?
Notice
Date,
of
date?
date is
23/12.
23/12/22.
23/12/22.
Yes,
Okay.
page 27.
Hmm.
You are hereby informed that you have, from the report of the local inquiry, you have been illegally enjoyed the possession of an area measuring land so and so, tag number 8011, whereas I am possessing the land 811, situated in Kasalokwa, Moja town, has been running in the name of Nagaon Municipality. You are hereby asked to vacate the land from your possession immediately, otherwise legal action will be taken. This notice was not served on me.
No, that's in the vernacular at page 28.
28.
It is not clear. What is the DAG number here?
DAG number written is 8011.
It is not clear. It is
It is not
801.
clear, but they have also admitted in their
Okay,
affidavit.
okay. Hmm.
But I am not occupying the land 801.
You are on 811.
81. My whole submission before your lordship is this. The land is not a municipality land. Land is a government khas land. How the municipality can evict me from the land? Therefore, whole eviction process is illegal. And therefore, as I have already evicted, my position is to be restored there.
You have already been evicted.
Yes.
But is the land still lying vacant?
In their affidavit, they have not stated they have not submitted any document that the land is a municipal area's land. It is a government land. How the municipality can evict me from the government?
Okay. What is the status of the land after your eviction?
After my eviction, it is still a khas land.
No. Is there any structure? Is it utilized by the government? Utilized by the municipality?
No.
Is it vacant?
Vacantly.
Now, on the aspect of authority of the municipality, are you citing any decisions?
Decision, my lord, I haven't. But apparently, the municipality in their affidavit, they have not stated anything that the land belongs to the municipality. Therefore, the municipality has no authority to evict me from the government land.
Mr. Count, you are for the municipality.
Municipal government,
You are the contesting respondent.
Yes, 3, 4, and 5.
What do you say?
Then let me reserve for municipality.
Land is reserved for municipality.
Yes. Very much.
No, it doesn't matter. Which page? Page, Mr. Sharma, have you seen? You have filed your affidavit.
Yes.
When?
Affidavit in there.
You are 3, 4, and 5.
3, 4, and 5. Now kindly read from
You
paragraph.
file affidavit on 11/11/24. Yes. Yes. Which paragraph?
Para number 10.
10. Okay, page 35.
The legal statement in para number that is, the deponent said that as per official record, the executive officer issued a letter by so and so to the circle officer Nagaon, Pador Avenue Circle, requesting him to depute the concerned Mondal to identify the land of DAG number 811. And then after field verification of the said land by the Mondal and junior engineer of the board, both of them jointly submitted the report stating that the said land is enclosed by one Isa country. That is the petition. Thereafter, that is, and in that report, that is Annexure B at page 44, 45.
Now, first, we want to see the records by which this land in question. We are not on the aspect of the DAG number, whether it is 8011 or 811, that may be a mistake, which we have already seen in your affidavit. But first, we are interested to know how this land was allotted to you.
Kindly go to page number 44, Annexure B.
44.
44. And origin is in Annexure 45. Kindly go to this Annexure B,
44.
page at page 45.
45. 45 is the vernacular.
Yes.
Please read.
পৌরসভার নামত থকা মিচিকোৱা and
Of land municipality. What is MCQA? What is MISIQA?
that reserved for municipality, and Koa is that is not well, but as I had informed or instructed that it is a low-lying land. During British era, in that land, some garbages of the locality had been thrown. And thereafter, when those garbages dried, then set on fire. For that purpose, this land was reserved. And as per official record, that is reserved for municipality. Oh, I see. The presentation. And it is. Then kindly go to page number 43, copy of the SITA, content SITA.
Page number
43.
43.
In serial number 1, that is DAG number 811, class of land matrix Reni, no, nice. Area of land 15 Lusa, then number of patta and kind of land, Sorkari. Then come to the 31, serial number 31,
Yes.
Modolo Toka, Misikwa.
Oh,
That is. So it has been reserved for municipality for that purpose. During the British era, that was called Kua. And now, as per the report, joint report of concerned Mondal, and also junior engineer of the Nagaon Municipal Board, as I have already submitted to your honor at page number 44 and 45.
yes, we have seen this.
Yes. So that land reserved for municipality. And the petitioner is an enclosure to that land.
Okay.
and therefore municipality has issued the notice. Now, prior to that, I want to submit that some facts which has been stated by the petitioner in his written statement actually are not correct. Regarding, I want to submit that his right has been violated, as because his claim is that he is doing business on that plot of land since 1979, as it revealed from the writ petition itself. But along with the writ petition, the petitioner failed to submit relevant documents that he is doing business till the date of filing of the application on that plot of land. And what document he has submitted, that document is kindly go to page number 14.
14. Yes.
That has been a trade license issued by Nagaon Municipal Board in the name of Isa Kansari to doing business at Moniram Dewan Road, ward number 13. And the document relates to 1985-86. 85-86. They failed to submit any document that trade license has been issued by the Nagaon Municipal Board, or on that plot of land, the petitioner is continuously doing business on that plot of land till the date of filing of the petition. No such document has been filed. Secondly, in our para number,
But what about page 19? Do this license, you may be correct in contending that this was till a particular period of time ending on 31st of March 1986.
up to 1993-94.
Then at page 19,
93-94.
yes,
Not
no, this is of 2001, page 19.
No, my lord. That is page 19. It no. Yes, page 19.
What is the date?
That
26
money has been, fees has been paid on 26 to 2021. But kindly go to the contents. 2001. Kindly go to the contents. It is from 1987, 1988 to 1993-94. 87-88 to 1993-94. This is the only document he has submitted. The petitioner submitted that yes, up to 1993-94 he is in. For the sake of it, let us assume that yes, he is doing business on that plot of land. That is that to up to 1993-94. So that statement, which has been made by the petitioner in written statement, that he is continuously doing business on that plot of land, it is purely false. And his no right of his has been violated. Then I want to lead your honor to page 6 of our affidavit in opposition as page 34.
34.
Yes, my lord. Para number 6. I will to read it for your honor.
Please.
That as regards the statements made in para number 4 of the petition, the deponent said that Nagaon Municipal Board issued trade license in the name of petitioner for doing business over his own plot of land situated at Moniram Dewan Road, and not on the above mentioned 15 acres of land covered by DUG number 811.
Oh.
That is, he has own plot of land in the same ward, in the same road.
Let us see the response to paragraph 6?
They have simply denied it.
Six, yes, at 63. Paragraph 8.
That as regards that made in para number 6 of the affidavit in opposition, the deponent begs to state that the petitioner has been in continuous, peaceful and open possession of plot of land covered by DAG number 811 since the year 1979, conducting his business openly without any interruption, objection or dispute from any quarter, including a respondent authority. The petitioner's disputed possession of the said plot of land.
There is no denial. There is no denial.
No denial.
He is taking out, projecting another case.
Another
that
case, my lord.
the area in question is under continuous possession for a long period of time.
Exactly, my lord. And
But
has
that
been
license
stated-
is not connected to this plot.
Exactly. And that statement has been made in para number 4 of his petition, my lord. That what statement has been stated in para number 8 of the proposition. And then some documents also filed by the petitioner another point I want to draw the attention of your lordship that he has also stated in your in his petition that he has residential house thereon, but that is also not correct. By erecting the word used by him, by erecting residential house on that plot of land, that is also not correct. He has own plot of land where he resides with his family.
Okay.
And kindly go to page number 24, annexure 5. There is a petition filed by the petitioner before the deputy commissioner for allotment or granting of patta in the civil land. Now, in that petition, if we go through it, then I'm able to read it for your lordship.
Yes, please.
Humble submission is that I am the permanent resident of the above mentioned address. The financial condition of my family is very bad. In the name of mine or in the name of any member of our joint family, have any kind of periodic Miadi land. That is also a false statement. Since days of my grandfather, or since 48 years by strength of heirship, I have been living in the land described in the schedule land below, that is government land, by erecting houses thereon, by running a shop of broken metal, iron, etc. At present, it is required to obtain patta lease in my name in the land described schedule below. That is. By making false statement, he tried to get the land, for settlement of the land. Now, whatever it may be, admittedly, it is admitted fact that the petitioner is an illegal occupier of that plot of land. For the sake of argument, if we assume that, yes, that is gov land, not reserved for municipality, then also by virtue of Rule 16, the petitioner is an enclosure, settlement rules, enclosure. Then, if a person is enclosure in respect to a particular plot of land, then the authority has the right to evict that person even without serving a notice. And that has been revealed in sub-rule 2 of or rule 18 of the settlement rules. Rule 16, prohibition to enter into land until issue of lease. Rule 16 of settlement rules.
Yes.
Prohibition to enter into land until issue of lease. Lease shall be issued on written application only, and no person, that is important, no person shall enter into possession of wasteland in any area until a lease has been issued to him, or otherwise a written permission by Deputy Commissioner has been granted to him, pending issue of such lease to enter into possession. So, until a lease has been issued or permission has been accorded by the concerned authority, if any person entered over a government land, then he shall be treated as encroacher because he has no legal right. Then, what is the consequence? I may be allowed to read Rule 18. Ejectment. Sub-rule 1. Subject as hereafter provided, the Deputy Commissioner may eject any person from land over which no person has acquired the rights of a proprietor, landholder, or settlement holder. Then sub-rule 2. When such person has entered into possession of government class land or wasteland or estate over which no person has acquired the rights of a proprietor, landholder, or settlement holder, or any land that has previously been reserved for roads or roadside lands or for grazing of village cattle or for other public purposes. I give stress on the words for other public purposes, that our land is reserved for municipality for public purposes, or has entered into possession of land from which he has been excluded by general or special orders, and when further there is no bona fide claim of right involved, he may be ejected or ordered to vacate the land forthwith, and the Deputy Commissioner may sell, confiscate, or destroy any crop raised or any building or other construction erected without authority on the land. Now, kindly go to sub-rule 3A. This sub-rule has been started with those in all other cases. That means except the, as mentioned in sub-rule 1 and sub-rule 2. All other cases, ejectment shall be preceded by publication of a notice. So, our case comes within the purview of sub-rule 2. Therefore, without a notice, such person can be evicted. For the sake of argument, yes, that number has been wrongly written. Then also, when the law says...
Mr. Khan, the 18, these powers are meant for whom?
That
is it meant for the municipality? It is not meant for the municipality. We understand the difference between 18.2 and 18.3.
Yes.
18.3 envisages issuance of a notice in other cases, in cases which have been described in 18.2, notice may not be required. There are various interpretations. Division bench in Salakuddin has also clarified. But here, Mr. Sharma perhaps is not even arguing that. He is questioning the authority.
Yes.
Whether municipality would have taken recourse to such an action. In fact, fortunately, your notice does not mention 18. You cannot exercise 18.
Exactly. No, therefore, I am submitting before while I'm making submission on that point. For the sake of argument, let us assume that this is the government. Therefore, I'm starting with these words. Now, so.
No, if you assume, then it's for the government to carry out the eviction proceeding. Whether your notice is required or not, even if you do not go into that question, then the authority lies with the government. Perhaps that will not be a proper course of argument for you. You are sticking to your argument that this land was allotted to the municipality. The Chita also says, the field verification also says municipality land. I think that will be suffice.
Yeah. Then, on that point,
yes,
my submission will be Section 159 of the Assam Municipal Act.
Assam Municipal Act. Which section?
Section 159.
159. Yes.
Removal of obstructions or encroachments in or on public road. The board may issue a notice requiring any person to remove any building which he may have built or any fence, rail post, or other obstruction or encroachment which he may have erected on any public road, house gully, public drain, sewer, aqueduct, water course, ghat, or any land vested in the board, And if such person fails to comply with such requisition within 48 hours of the receipt of the same, the magistrate may, on the application of the board, order that such obstruction or encroachment be removed, and thereupon the board may remove any such obstruction or encroachment, and the expenses thereby incurred shall be paid by the person who erected the same. So that land is vested with the municipal board, as I have already submitted to your honor. So municipal board has a right to free the land from encroachment as per section 159. And accordingly, notice was issued. And that notice twice the process server went to serve the notice for causing service of the notice upon the petitioner, present petitioner, but he refused to accept the notice. That report has been given by the process server to the executive officer of the board.
Yes.
I want to lead your lordship to page number 10 of my affidavit in opposition as page 35. That is part of
Paragraph 9.
paragraph 10.
10 you have read already.
I have read out, but part of the paragraph 10 is also
We have
36.
read this.
30,
We have
regarding
read,
that report.
we have read it. We have seen the photographs.
Yes, that is. So, and then subsequently, that notice was served by affixing a copy of the notice on the concerned land. And time has been given, and in spite of that, the petitioner did not file any objection before the authority, and the eviction was also done on September 2023.
7/2/2023.
7/2/2023. And the notice was affixed on 10/1/23. Almost 1 month. Weeks. Okay. And if we go through the section 307 of the municipal act, how notice etc. may be served. Every notice, bill, form, summons, or notice of demand under this act may be served personally on or presented to the persons to whom the same is addressed, or be left at his usual place of abode with some adult male member or servant of his family. Or, this is third, if it cannot be so served, presented, or delivered, may be put on some conspicuous part of his place of abode, or of the land, building, or other thing, in respect of which the notice, bill, form, summons, or notice of demand is intended to be served, or may be sent by post in a registered manner. So by this mode, that notice was served. And regarding Dag number, my lord, yes, he is occupying Dag number 811. And in the notice, it was inadvertently mentioned that 80111 additional 0 was added there. Now, when that notice has been affixed on DAG number 811, we can safely presume that the land on which the notice was affixed, the eviction is to be made in respect of that land, And the notice was affixed upon the land of DAG number 811. Therefore, there cannot be any hesitation to understand that this particular plot of land is meant for eviction. But about almost 1 month, the petitioner remained silent. Thereafter, eviction was done. And thereafter, the petitioner came to this court for seeking relief. And if we go through the prayers, then prayers of the petition, then also all the
Page 11.
Page 11. Prayer number 1. A writ in the nature of certiorari should not be issued for interfering with the quashing of eviction notice. Eviction notice has, by that notice, already eviction was done. Then mandamus should not be issued, thereby commanding the respondent to rescind recall that already been acted upon. Then a writ in the nature of mandamus directing the respondent number 3 to restore the possession of the aforesaid land. Here, admittedly, the petitioner has no semblance of right. Therefore, what
When was the eviction actually carried out? You said 7-2.
7/2/23.
7-2. And this writ was presented on 16 March 23. 16 March.
Yes.
So, and by the time eviction was already done. But there is a prayer for restoration of possession.
So, the petitioner must have some semblance of right. Mere length of possession does not confer any color of right, not to speak of any right.
Okay.
Could you find it? If you report has said. I have a decision of this honorable, but it is related to Rule 18. Rule 18.
Yes.
Yet the principle laid down regarding length of possession, I think that principle can be, of course, I do not know exactly, can be applicable here also. Yes. I'll say this.
Yes. Why are you referring this?
Can you say para number 24 at page number 369?
24. Yes.
for principal. Having regard to the entire conspectus, facts and circumstances obtaining in the case in hand, it has emerged that the parcel of land the petitioners are found occupying are reserved for public purpose of inland port, and they are now required for project of so and so, which is a project of public importance. The provision of Rule 18.2 is found applicable in case of such parcels of land, meaning thereby the petitioner cannot be termed in any manner other than enclosure. Such status as enclosures merely because of the fact that the petitioners are in occupation of the parcel of land for about 3 decades, as claimed by them, do not change due to long elapse of time, and as such, they do not have any legal right to claim protection from eviction from the parcel of land under their unauthorized occupation, as the payments they have been purportedly making in the name of revenue is only bedokoli jorimana, that is encroachment penalty, which is interchangeably known as Tojibahi Khajana. The length of possession does not confer any title or any right, even a color of right.
Okay.
And the very last 4 lines, obtaining electricity connection in their names, enlistment of their names in the electoral rolls, etc., do not improve the status of the petitioner vis-a-vis the parcel of land under their occupation from the status of enclosures.
Yes.
So, from whichever angle we see, the petitioner is not entitled to get any relief as claimed of this.
Yes, Mr. Sharma, anything?
My submission, Rule 18.2 is not applicable in this case. And the Section 307 of my land of that is also not applicable. The length of possession, what my learned friend has submitted, it is immaterial so far this case is concerned. Our case is that without issuing any notice to us, we were evicted. And in notice, they were annexed the photographs. Photographs are not admissible in evidence. It is not mentioned who are the person appeared in the appeared at the site and who affixed this and who took this photograph. Nothing is there. Therefore, Your Lordship can disbelieve these photographs. Photographs say page 54 and 55.
See, these are writ proceedings. There is no avenue to adduce evidence. So we go by your pleadings.
Yes.
The photographs, the averments in connection with the photographs have been given in paragraph 9. Let us see your response to paragraph 9. There is no denial. You have said whatever you have said in the writ petition, no prior notice. That is your statement.
Well, the another thing is this, my lord, paragraph 9 of this.
That those averments are in paragraph 9.
In my affidavit in
And
opposition,
in prayer
paragraph
number
11.
12 also that is mentioned. Regarding
Yes.
eviction in prayer number 12 also mentioned.
The deponent denies the abandonment made in the respondent's regard. The deponent begs to state that despite the petitioner's long-standing possession over the set and settled business of the set, the respondent municipal authority in a wholly arbitrary and illegal manner forcibly arrested without any issuing prior notice.
You have not even dealt with the aspect of photographs being affixed. Or photographs being taken of the notices at the time when notices were affixed.
In their affidavit, they have stated that it is affixed on my premises.
Yes.
And my lord, so far the other notices that were served on me,
Hmm.
that they have annexed the report of the Nazir, page 49.
Hmm.
আপোনাৰ নিৰ্দেশ মতে মহম্মদ ইনচাৰ আনচাৰী জাননী দিবলৈ যোৱা 23-12-22 তাৰিখে আৰু 24-12-22 তাৰিখে ইছাক আনচাৰে জাননী ল'বলৈ
Hmm.
অমান্তি হয়। মানে this whether there was any witnesses were there, that has to be stated in the petition and the report that I went to serve the notice in presence of those witnesses. There are no witnesses. Therefore, the service of notice is not it. Therefore, my submission is this, that without issuing any notice, they evict me from the land. Therefore, that is illegally, apparently illegal, and therefore my
Okay.
position is to be restored. And so far the other points my learned friend has submitted, that the length of 307 of the Municipal Act, that has not application so far our case is concerned.
307 is not applicable. Why?
How notice may be served? Every notice, bill, form, summons, demand, we serve personally presented to the addressee. If he left the usual process without some adult members, if it cannot be served or delivered, put the same in the conspicuous place about the building, the notice, bill or summons intended to be served or may be put in the registered cover. No registered notice was issued.
Those are registered notices or. The expression is not and, it's or. There are various options.
Yes.
So if it cannot be so served, presented or delivered, maybe put on some conspicuous part of his place of abode, that's one. Or of the land, building or other thing in respect of whom the notice, bill, form, summons or notice or demand is intended to be served, or maybe sent by post with registered. These are standard modes. These will not be too much of a dispute in all cases.
But my case is this, the notice was not duly served. And the eviction, it is also disputed whether it was served in my premises or not, it is not. There is no such, any averment that the municipal people went to my place and affixed them. Therefore, there is no service of notice.
Okay. The instant writ petition has been filed with the following relief court order. As per the facts projected, the petitioner claims to be in possession of a plot of land measuring 15 lechas covered by DAG number 811 of town Kachalukhoa, Kismat, Musa town, district Nagaon, and is earning his livelihood by carrying on business since the year 1979. Full stop. It is also averred that the respondent number 3, namely the Nagaon Municipal Board, had issued a trade license allowing the petitioner to carry on his business, and the trade license was extended was renewed from time to time, and municipal tax was also paid. Full stop. The petitioner also claims to have made an application before the additional deputy commissioner, Nagaon, on 18/5/2013 for grant of, for registering his name in the TOJI register by contending that he is in possession of the land since a long period of time, and on the said application, a report was submitted by the circle officer on 4/7/2013. Full stop. It is contended that the land in question is government land where the petitioner is residing. Full stop. The petitioner had thereafter made another application on 22/6/2022 with a prayer to make settlement of the land in his name, and some enquiries were also made in that regard. Full stop. It is the case of the petitioner that when there was a move to settle the land in his favor, the respondent number 3, without service of notice, had demolished the structures of the petitioners on 12/2/2023. Full stop. The petitioner has also contended that though there was a notice dated 23/12/2022 issued by the respondent number 3, the dark number was written as 8011, whereas the petitioner was in possession of a plot of land covered by dark number 811. Full stop. The aforesaid action of evicting the petitioner is the subject matter of challenge, and one of the prayers is to restore possession, which has been extracted above. Para. I have heard Sri Ishi Sharma, learned senior counsel for the petitioner, assisted by Sri Sutradhar. Yes. S. Sutradhar. I have also heard Sri and Goswami, learned state counsel, and Sri S. Count, S.A. Count, learned counsel for the respondent number 3, Nagaon Municipal Board, 3, 4, and 5. 3, 4, and 5, namely the Nagaon Municipal Board and its officers. Para. Sri Sharma, the learned senior counsel, has formulated his arguments in the following manner. Number 1, the land in question is not municipal land, and therefore the respondent number 3 did not have any authority to carry out the eviction proceeding. Number 2, the land is government khas land where an application for consideration for settlement was pending, and if any action was to be taken, it was to be done by the state and not by the municipality. Full stop. Here's number 3. No notice was served to the petitioner before the eviction process, and therefore there is gross violation of the principles of natural justice. Next. Even if it assumed that a notice was issued, the contents of the notice was not pertaining to the land in question, and therefore could not have been treated to be a notice for eviction. Full stop. Where the learned senior counsel has submitted that as the entire action was done without any authority of law and in gross violation of the principles of natural justice, the same is required to be interfered with and possession of the land in question is required to be restored. Para. Per contra, 3 count, the learned counsel for this respondent numbers 3, 4, and 5 has strenuously opposed the writ petition. Full stop. By drawing the attention of this court to the affidavit in opposition filed on 11/11/2024, the learned counsel has submitted that the basic premises on which the writ petition has been structured is factually incorrect. He has submitted that the land in question is municipal land over which the respondent number 3 has full authority. He has drawn the attention of this court to the averments made in paragraph 10 of the affidavit in opposition, read with the enclosures, which includes a joint report by the junior engineer and the Lat Mandal, and also the chitha in which the name of the municipality is recorded. It is submitted that though the petitioner has stated that he is doing business since the year 1979 till the date of eviction, no documents were enclosed to the writ petition. Full stop. He submits that though there is a trade license enclosed, the same is of the year 1985, and the fee receipt would show that fee up to 1993-94 has been paid, and there is no document to show that either the trade license was renewed or that the fee was paid. He accordingly denies that the petitioner was in continuous possession. Full stop. The learned counsel for the respondables 3, 4, and for the contesting respondent has submitted that the trade license was issued to the petitioner to carry on business from his own plot and not from the land in question. And in this regard, he has drawn the attention of this court to the averments made in paragraph 6 of the affidavit in opposition. He has also submitted that there is no residential house over the aforesaid plot of land, and an incorrect statement has been made by the petitioner. Full stop. He has also, by drawing the attention of this court to the averment made by the petitioner regarding submission of application for grant of patta, where he has claimed to be landless, the learned counsel has submitted that such statements were also incorrect. Full stop. Drawing an analogy to the Assam Land and Regulation and the rules framed thereunder, the learned counsel has referred rules 16 and 18 and has contended that the procedure adopted by the municipality has been done in a fair manner, wherein appropriate notice was given to the petitioner. He has drawn the attention of this court to the averments in the affidavit in opposition, wherein it has been contended that on 2 occasions notices were attempted to be served upon the petitioner, which was refused. And in this regard, there is a process server's report Full stop. Ultimately, on 10/1/2023, the copy of the notice was affixed at conspicuous place and even at the premises of the petitioner. He submits that if the petitioner had any good reasons, he should have submitted his show cause reply, as the eviction was done after almost a month thereafter, on 7/2/2023. Full stop. By drawing the attention of this court to the Assam Municipal Act 1956, the learned counsel has referred to section 159, which is on the aspect of removal of obstructions or encroachments in or on public road. As regards the aspect of issuance of notice and the procedure prescribed, the learned counsel has referred to section 307 of the aforesaid act and has submitted that the due process has been followed. Full stop. On the aspect of the DAG number 811, the learned counsel for the respondents has submitted that it was by inadvertence that the DAG number was incorrectly written as 8011 instead of 811. Full stop. He, however, hastens to add that the same will not have caused any prejudice, as the notices were affixed on the premises which was sought to be evicted. And in any case, the aforesaid aspect was never raised by the petitioner before the authorities during the time allotted to him. He submits that there is no right of any nature of the petitioner to claim either possession or restoration thereof. Full stop. He has also relied upon the judgment of Jubar Ali versus so and so, reported in so and so, and has relied upon and has and has submitted that length of possession will not confer any right. Para. Sri Sharma, the learned senior counsel, has submitted that Rule 18 of the rules framed under the Assam Land and Regulation will not be applicable in the instant case. Full stop. He has reiterated that notices were never issued before the impugned action. Full stop. As regards the photographs which have been enclosed to the affidavit in opposition, the learned senior counsel for the petitioner has submitted that such photographs cannot be treated as admissible evidence. For full stop. He has also submitted that there is no averments giving the details as to the procedure adopted, including the names of the person who had gone there to affix the photograph and in whose presence affix the notices, and in whose presence such notices were affixed. Full stop. He submits that mere annexation of the photographs with the affidavit in opposition will not be a conclusive evidence that notice was actually served. The rival submissions have been duly considered. The first contention is that the land in question is not municipal land, and therefore the authority of the respondent number 3 has been questioned. Full stop. To consider the aforesaid submission, this court has gone through the pleadings, including the annexures of the affidavit in opposition filed by the respondent numbers 3, 4, and 5. Full stop. Apart from the denial of the averment that the Nagaon Municipal Board was not allotted the aforesaid land, comma, a clear statement has been made in paragraph 10 of the affidavit in opposition, which is extracted herein below, paragraph 10, page 35. This court has also noticed that a joint inspection was made and a report submitted by the junior engineer and the Latmander, in which the land has been described as municipality land. Full stop. The matter, the aforesaid contention is also fortified by the chita, which has been enclosed to the affidavit in opposition. And so far as the land in question is concerned, the name of the municipality is recorded. Full stop. In view of the aforesaid, the aforesaid contention and averments have been dealt with by the petitioner in the rejoinder affidavit filed on 23/5/2025. Full stop. A perusal of the same would, however, not lead this court to a conclusion that there has been any specific denial. Full stop. As regards the contention that no notice was served, comma, the materials on record would show that the notices were attempted to be served on 2 occasions, which the petitioner had refused to accept, and therefore the notices were affixed in conspicuous place in the locality as well as in the premises. Full stop. In support of the aforesaid plea, the relevant photographs have been enclosed. Full stop. Though Shri Sharma, the learned senior counsel for the petitioner, may be correct in contending that such photographs are not conclusive evidence, comma, the same can, however, be treated as a prima facie evidence to show that the procedure laid down in section 307 of the Act was followed. Full stop. This court has also noticed that there is no denial of the aforesaid averments made in the affidavit in opposition by the petitioner in his rejoinder affidavit. Full stop. As regards the DAG number, as regards the discrepancy in the DAG number, comma, it is apparent that the land in question is covered by DAG number 811, and the eviction notice had mentioned the DAG number as 8011. Full stop. However, this court is inclined to accept the submissions advanced by Sri Kaund, the learned counsel for the respondents, that when the notice was affixed in the premises and a period of about 1 month had elapsed since affixation of such notice till the date of eviction, where the petitioner did not even attempt to make a reply, comma, the same cannot be said to have caused any prejudice to the petitioner in defending his case. Tara, in view of the aforesaid discussion, no, arata likhito. This, in the case relied by Sri Khan of Jubair, so and so, Supra, there is a reference to the landmark case of Radha Kanu versus so and so, reporting so and so, wherein it has been laid down that payment of Toji Bahira cannot vest any right, as the same is treated to be a penalty for encroachment, for use of land. Full stop. Para. In view of the aforesaid discussion, this court is of the opinion that no relief, that the petition is not entitled to any relief, and accordingly the petition is dismissed. Yes.
I would like to.
Seven to nine, leave it for any other bench. Eleven and 12. Yes, madam.
May it please your lordship. Lordship, this matter was supposed to be disposed of considering the instructions were sought for on the last date, lordship. However, it has not come forth.
There's a direction to file affidavit. Everything is ready, lordship. Within 2 days we file it.
You'll file affidavit.
There's a direction to file affidavit. No, we'll file it. It is ready, lord.
Okay, when can you file? This week you can file?
No, lordship, we can.
We'll have it on next Thursday.
Lordship.
Lordship.
Okay. Sri N. Goswami, Learned State Council submits that the affidavit is ready and would be filed during the course of this week.
Lordship.
Sarah? As agreed to by the Learned Council for the parties, list for admission hearing on
27.
27 to 28,
28.
Thursday. What is this quantum, madam?
Lordship, this is with regard to an interim order that was passed in this case. However, it was not followed. But according to them, they have already given the settlement to someone else during
Yes.
the proceedings, lordship. That's why this matter was supposed to be taken up for final disposal.
Okay, Thursday.
Much obliged. Lordship.
Yeah, for the respondents.
Yes, lordship.
Petitioner, B. Sinha, H. Islam.
Lordship, matter may be passed for the time being as my senior is on legs.
Who's your senior?
PK Decker.
He's for the petitioner.
No, for the respondent.
Respondents, then it is for the petitioner to start. If they are not there, you will not be too much worried. Okay. None appears for the petitioner on call.
Maybe, lordship.
Okay, yes.
After some time, lordship, my senior on the way.
Who is your senior? B. Sinha?
Be senior, lordship.
What are these matters?
After few minutes, lordship.
What are these matters? Where is Mr. Dekha? He's there or not?
Yes, lordship. He's on legs at court number 8.
Oh, after a while, let Mr. Dekha also come. Okay. I think 48 and 58.
This case, na?
Lordship, may first take up IA Civil 2715.
Also, right, sir?
48 to 50. Huh? But orders need to be more. IA to okay. We have taken up the IA what?
Yes, yes.
IA for?
IA for substitution of legal heirs of read petitioner number 5.
5 has passed away.
5 have passed away.
I have stated in paragraph 2.
You are the applicant.
Yes, my lord, repetitioner, one of the
Yes,
repetition.
what do you say? No problem. I
No
think.
problem.
Yes, Mr. Pradeep.
We have responded from 5 to 12, my lord, in this.
So we allow the substitution.
That we allow.
Heard. Sri M. Doctor, learned counsel for the applicants, writ petitioners who by means of this application has sought for substitution of the of the petition number 5 by his legal heirs. Full stop. It is contended that the respondent number 5 has passed away on
Petitioner, my lord.
petition number 5 has passed away on
15/05/2025.
15/5/2025 during the pendency of this writ petition, and as the cause of action survives and as the right to sue survives, the present substitution is necessary. Para 3 and Goswami, London State Council, and Sri Chaudhary for
Respondent number 5 to 12, my lord.
Respondent number 5 to 12 do not object to the aforesaid prayer. Para. In view of the aforesaid discussion, the instant is allowed, instant application is allowed, and the petition number 5 is allowed to be substituted by his legal heirs who are named below. 5 on the death of page 4 page 4 5 লিখিবারে 5A 5B 5C I hence disposed of in the writ petition you write. Writ petition is of which year?
2024, my lord.
Okay, in the writ petition you write, IA number so and so has been allowed for substitution of the response of the petition number 5 has been allowed today. That is as it did. Learned counsel for the petitioners is required to file amended cost title within a period of 1 week. 1 week. List the writ petition thereafter.
My lord, may I point out one thing, my lord? My lord, this court, High Order dated 10/2/2025, my lord, directed to place a copy of the award passed under section 23 of the Right to Fair Compensation Bill. So that has not been placed yet, my lord. And my lord,
You and on the next day you bring it.
and there is an interim order that may kindly.
Interim order passed earlier to continue till the next date of listing. The writ of purpose. Yes, next.
Deeply obliged.
Yes,
Yes, my lord, as per last order, one specific instruction was sought for. From the
yes,
bank.
where is Mr. Sharma? Here for Mr. Sharma?
Yes,
Where is he?
we have filed affidavit, but the manager has changed and we need some time for instruction. And on the next day, we will file our affidavit.
Otherwise, my lord, the answer is in the affidavit itself, my lord. They have said that,
How soon can you file the affidavit? But you have already filed affidavit.
yes, already filed.
Again,
Why a further affidavit is required?
that senior has mentioned.
Huh?
My senior has informed me. that-
Okay, well, we'll have in our senior's presence. When?
3 weeks.
On Monday. Monday is a holiday. On Wednesday next.
Wednesday. next.
Wednesday.
2 to 3 weeks time.
For what, my lord? We
Let-
don't
let-
know complete,
Instructions are made.
right from beginning, my lord, they have been.
No, on
avoiding-
Wednesday next. If it's required, if we feel that more time is required, we'll grant, but not like this. Okay. Those three, I, Borthakur, Learned Counsel for the petitioners is present, comma. A prayer for adjournment has been made on behalf of M. Sharma,
B. Sharma.
B. Sharma. B. Sharma, who was B. Sharma? Okay, B. Sharma, okay, B. Sharma. Well, in view of the above, this for admission hearing on Wednesday next. Not tomorrow. Next Wednesday.
Obliged.
You want to go? Seven. Yes, Mr. Decker.
Yes.
Mr. Sinha.
My lord, in this matter, my lord, I filed one my lord, for modification interim order. If my learned and senior friend is ready to dispose of the matter, I'm ready, my lord. So, cooperate with Department of Council. So disposal, my lord. And before taking out the matter, 3 questions I could place, my lord. So far as the locus of the present petition in this matter, regarding the maintainability of this matter and regarding, since, my lord, the order challenge before this court, there is no interim stay on that order. Subject and another order they have challenged, but original, the main impugn order, there is no stay order. And moreover, my lord, the order is a challenge before this court. It is a appealable order, my lord, under 1113. That's question will come. Also, government has filed affidavits on this point. So let me start on merit, my lord.
Yes, Mr. Sinha.
Yes, my lord.
Locus.
Locus, I am the member of the society. As a member of the society, I don't know why. I'm the member of the society, and my lord, the appeal has been filed by respondent number 5. Whether appeal is maintainable. I have challenged that whether appeal is maintainable. In the appeal, the impugn order has been passed.
You are a member of the society.
Yes, my lord. Cooperative society, my lord. Because the cooperative society was the board of the society was dissolved.
Okay, let us.
Yes.
Which one you would like to place? 3421.
Yes, but 3421 is the writ petition.
Whichever, there are 2 writ petitions. Oh, I
No, this is IA, that is IA.
You want to refer to the writ petition?
Yes, my lord. I
3421.
think entire writ petition to be heard, my lord.
Okay.
Yes, my lord.
Yes.
Yes, my lord. So, my lord, your lordship will find the impugn order.
Just a minute, please. 3421. 24. B. Sinha. Page
It starts from page 69,
69.
Annexure 20.
69.
And the operative part is at page 78.
69. What is this 14 June order?
Yes, my lord. This is passed by the, my lord, Juvenile Joint Register of Cooperative Societies, Silchar.
What is this order?
Yes, operative part, page 78.
Such a long order.
Yes, long order, maybe very long order. Now, the operative part will do the, my lord, the needful things, my lord. In the light of the above and in the entire public service and to meet the ends of justice, I see so and so, Kasar Congress, Hailak and the Silchar, in exercise of power delegated under section 1111 of the Act, do hereby withdraw the order issued by number so and so 1124, appointing officer on management in the society, resulting into restoration of board of director of the society constituted on 28/8/2022. Subsequently, they are allowed to continue functioning for the rest of their term as per the provisions of under section 40, clause 1 of 42 of the Act. It is also ordered that BOD shall take cognizance of claim of Sri Rajesh Das in the light of above arguments and to allow him to continue as a member of society if he is not eligible otherwise. Yes, my lord. Now here is a, my lord, question arose, my lord. Yes. Now here the Registrar of Societies has withdrawn his order, which has passed on 1/1/24. 1/1/2024, he has withdrawn the one-man committee, my lord. One-man committee, whereas there is no appeal against that one order, my lord. Against that order, no appeal filed. Against the order dated 1/1/24, no appeal was, that order was not challenged by anybody before him, before the appellate authority.
But one-man committee is a temporary measure.
Yes, yes, temporary
Is it
measure.
required to be challenged?
My lord, if anybody, my lord, if anybody,
No, is it required to be challenged? Is it not? This
my lord,
is-
because it has completed its term also. I don't know why he has withdrawn it. He has already completed the term of 3 months. Already completed.
Then the BOD.
Then they could not constitute any general meeting or general body. So another one-man committee is to be appointed. But in spite of that, on the appeal of Mr. Rajesh Das, Mr. Rajesh Das, this order has been passed. On the appeal of Mr. Rajesh Das.
You
What?
said,
Yes.
you
what-
said there was no appeal, no challenge. Now you're saying that one Rajesh Das is there.
No, Rajesh Das filed an appeal against his membership. Not for this. Membership, he has filed an appeal.
Membership means? we have-
Membership of the society. That he is a member of the society.
No, Mr. Sinha, you have to place the facts. You are aware of the facts. We are
Yes,
not
ma'am. Yes, now
we
I
are not
am
aware of the facts. Let's
Yes,
see.
yes,
What
now-
what is discernible that there was a board of directors which was replaced by a one-man committee.
One-man committee.
On 1/1/2024.
1/24.
Now this, by the impugned order of 14/6/2024, this one-man committee constitution has been revoked, and the board of directors have been restored.
Restored.
Why are you aggrieved?
No. Yes, I was. How I am aggrieved? How this Rajesh Das comes in the picture?
No, who are you?
No, I am a member, society member. Member of the society.
Okay,
I've
how are you aggrieved?
Yes, madam, because this order, how it can be? How this
You don't want the board of directors to run the society.
no, board of director cannot be restored.
No, you do not want the board of directors to run the society.
I want,
Then?
but how this board of director comes here? Because one-man committee is appointed. Now, why one-man committee was appointed? That is to be seen, why not? Why one-man committee was appointed? Now, I will take your lordship to Annexure 18, page 65. Prior to that, Annexure 17, page 62, and a representation was filed by Mr.
I think,
Rajesh
Mr.
Das.
Sinha, you have to place the facts first.
Yes,
You
madam,
cannot just
please.
jump
Then-
with annexures like this.
Yes, madam.
Place the facts in a chronological manner. Let us understand then.
Yes,
What is
yes,
the
madam.
issue?
Yes,
What has happened?
Yes, madam. So why this impeachment order has been challenged? Now, your lordship will find how the managing committee was constituted. Yes.
First, start from the beginning. What has happened?
Yes, my lord. Yes, I'm coming to that. My lord, Annexure 3, page 27.
27.
Yes.
Yes.
The regular managing committee was constituted in the year 2016.
2016.
Yes, by AGM held on 16/9/2016.
Regular.
Regular board of director, committee of board of director was constituted.
Then
That on the meeting held on 16/9/2016.
this term is for 5 years.
Yes, for 5 years. So, my lord, it expires on 15/9/2021.
15/9/21.
21, it expires.
Yes.
Then, my lord, a notice was surprisingly issued by secretary of the society. That is page 31.
Yes.
To hold the AGM on 28/8/2022. To hold the AGM on 28/8/22, that is 13/8/22. Now, before that, your lordship, where the secretary has this power?
No, notice was issued by the secretary to hold the AGM on?
On 28/8/22, after expiry of the earlier committee.
Okay.
Now, in this regard, my lord, there is section 41(6). 41(6) operates, my lord, automatic. Section 41(6) of Assam Cooperative Societies Act operates, my lord. Clause 6 of section 41.
41-6.
Yes, ma'am. Where a board fails, may I read, ma'am?
Please.
Yes. Where a board fails to arrange for holding election before the expiry of the term of the board or delegates, or where there are no directors remaining in the board, on the board, the registrar shall convene a general meeting by appointing an officer of the cooperative department for constitution of the board within 90 days from the date of such appointment, and the officer so appointed shall perform all functions of the board during the said period of 90 days. Now, avoiding this provision, my lord, this notice was issued after expiry of the board. As after expiry of term of board, there was no board after 15/9/2021. No board was there. The provision was to be resorted to by this 41-6, but no, it was not, my lord, processed in the matter by this notice. Then one AGM was held.
Now, in a situation of this kind,
Yes.
what is the recourse of law?
Report the records of one-man committee to, my lord, come. From one-man committee is to appoint by the registrar, then registrar will hold their AGM and
Under what provision?
that 41-6. Registrar will arrange the meeting.
Yes.
Yes. Now, my lord, avoiding this provision, my lord, an AGM was held by this notice issued on 13/8/22. AGM was held on 28/8/22, and committee has been constituted.
Yes.
And committee has been constituted by resolution number 8.
Yes.
Yeah, by resolution number 8, adopting, resolving that the earlier committee, that is in the committee constituted on 2016, will continue. That those members will continue, and accordingly, the AGM, sorry, board of directors was constituted as per resolution number 8. So that was not challenged in before any appeal, my lord. Now, these things have been, complaint was made before the Asian Registrar of Societies. Now,
by whom?
By the members, my lord. By the members of the society.
Now, your grievances with regard to what?
My grievance is that the committee, the restoration of committee, this committee cannot be cannot hold the board of director of the society. This committee, my lord, because it was held by the AGM, which is expired body. That body cannot. Only by means of one-man committee only now this body can be constituted. Only by one-man committee, not by anybody.
Now, this 28/8/2022 committee constitution was not the subject matter of challenge. Then why did how did the one-man committee?
No. That is, my lord, by order 11/24, that committee was dissolved. Whichever committee now it is constituted,
yes,
the Junior Joint Registrar had dissolved that committee, my lord.
By which date?
11/24.
Who dissolved?
Junior Joint Registrar. Dissolved the committee, my lord, which was constituted on 28/8/2022.
And constituted a one-man committee.
One-man committee to hold AGM within the period of 90 days. That is your lordship, but page 48, Annexure 11.
48.
Yes. So these irregularities has been, when it was complained before the authorities, then inquiry was made, then this order was passed. Annexure 11, page 48.
Yes.
Considering the letter number so and so and communicated by the Assistant Registrar Cooperative Society, Sri Samujjal Sengupta, Junior Inspector oblique Auditor of Corporate Societies, Office of the Assistant Registrar of Corporate Silchar, is hereby appointed as Officer on Management to manage the affairs of the said society and to hold AGM public election and to constitute a new managing committee as per Assam Cooperative Societies Act. So, my lord, this was passed and he was preparing for holding the committee, my lord. In the meantime, this respondent number 5 has filed an appeal. Now I have to, my lord, for skip this chapter now. I have to go to the appeal of the respondent number 5 now. On that appeal, this order was passed.
Oh, he filed an appeal against 1/1/2024.
No. He has filed an appeal that he was not considered for membership. He was not a board of director. He was not considered as a board of director. He was not considered as a member of the society by that one-man committee. So he filed an appeal. Now appeal comes.
Yes.
Now this appeal comes by way of this representation, my lord. He has, that's respondent number 5. He has first filed a representation before the Assistant Registrar of Cooperative Societies, who did not entertain his representation that no, I cannot do it. Then against that order, he filed an appeal. That's why whether that appeal of respondent 5 is maintainable. So now your lordship will find his representation before the Assistant Registrar of Cooperative. There is page 17, page 62, annexure 17.
This is representation.
Yes, representation of respondent number 5. Now your lordship will subject regarding membership of Digoli Multipurpose Cooperative Society so and so.
Yes.
Subject is then we are not going to the inside the reference is petitioner name of that. Now on this representation, thou the assistant registrar passed and communicated his opinion, my lord. That is your lordship by page 65, annexure 18. That's I have to read it, my lord.
This representation was filed to, was submitted to whom? Assistant Registrar.
Assistant Registrar of Cooperative Societies, Silchar. Now, he communicated his opinion. Now, with reference to the subject cited above, I am to inform you that this office has perused and examined your petition dated so and so, as well as office record, and made following observation. As per this office records letter number, it is seen that you became a member of Digoli Pukuri Multipurpose Cooperative Society through co-option.
Where do you get Pukuri?
That is the name of society, my lord.
Where? Pukuri
That's
is not,
Silchar, my lord.
it is
Silchar
not,
in the,
Pukuri is not there.
sorry, sorry. Digoli Multipurpose Cooperative Society, not Pukuri is not there. Yes, my lord.
You are very fond of
No,
the
I have
Pukuri.
put this. Pukuri is not there, man.
Yes.
Yes, my lord. So, as per this office record letter number so and so, it is seen that you became a member of Digoli Multipurpose Cooperative Society Limited through co-option. So he was accepted as a co-option member. Man. Then under section 42(4) of Assam Cooperative Society, members who are enrolled through co-option are not deemed to have any voting right. It is there, madam. Under section 14, 2042(4), this co-option member does not have any voting right.
Yes.
Yes. In addition to the above, the tenure of such membership is coterminous with the tenure of board of directors of society. Now, under section 55 and 56 of Assam Cooperative Societies Act, when a member of a registered society dies, his shares and interest in the society shall be transferred to the legal heir or nominee of the deceased in accordance with the law. His share and interest is transferred to the legal heir. Now next, hence in this regard, the share and interest of the society of Sri Kumuduni Das shall be transferred to her nominee in accordance with the law. Therefore, her son, Sri Ranu Das is legally eligible for enrollment as member of the Faith Society as per provisions of Assam Cooperative Societies Act. Now, also, I would like also inform you that as per order dated so and so, a departmental officer conducted an inquiry regarding the affairs of Digoli Multipurpose Cooperative Society. As per said report, there is no provision for selling and purchasing of shares in registered cooperative societies. In regard to the issuance of fresh membership to a person, one should follow the provisions established by the Assam Cooperative Societies Act. Hence, in view of the above, your petition and claim of membership would not be entertained against the share of late Kumuduni Das, and you may apply to the management of the society for fresh membership, subject to provisions stated in the bylaws of the society and as per provisions of Assam Cooperative Societies Act.
Yes.
So here the registrar of properties has in fact that membership should be taken by say purchasing one share of the, you cannot be a member of the society, so you approach the so and so. Now against this letter, he has taken it that it is a decision of the Asian Registrar of Cooperative Societies, and he will file an appeal.
R55 will appeal.
Yes, my lord. The Rajesh Das has filed an appeal before the Registrar of Societies, Junior Joint Registrar of Societies. Now, on that appeal, this impugn order has been passed. Yes, on that appeal, the impugn order has been passed, and in passing the impugn order, he has restored the body of society which was dissolved by himself. By Registrar of Society, he has dissolved because irregularities found, because 41(6) has not been resorted to. So irregularities was there, that committee cannot hold the body or cannot hold the body of cooperative society. So he has dissolved the body. Now, in this appeal of his membership, the Registrar of Societies, there is Junior Joint Registrar of Societies, said withdrawn that earlier order, restoring the board of society, and also directed that the membership claim of membership of it to be taken into consideration by the board. Now, in that earlier body, my lord, your lordship will find that AGM was held, that the body constituted on 16/9/2016 will be the body of the AGM held on 28/8/2022. Now, in that body also, some persons have already died. 3 persons have already died, so that body also does not exist. That's why, my lord, in the mean, though we did not get any interim order, but there is a direction that the subject to the outcome of the writ petition that was there. Now, in the meantime, that body, whoever members are there is no chairman, there is no secretary actually, my lord. Now they themselves has taken as secretary, that themselves have taken as president, and they have issued a notice. That's why that notice I have brought to before this honorable court, and that proceeding was stayed by this honorable court in the IA. IA was only for that, because there was only 3 or 4 members are there. 3 or 4 members cannot take any decision, my lord. The existing members, there's Sobita Das, Chanchal Das, Putul Das.
Mr. Talukdar, how do you resolve this? Elections are heard to be held, AGM is to be.
No, my lord.
And how do you connect the appeal of R5 with the impugned order? There is no requirement.
My lord, eventually.
See, instead of a one-man committee, we all desire, even the law desires that it should be run by an elected board of directors. You have the elections matters there.
Yes. My lord, in fact, the challenge is with regard to the restoration of the board. So eventually, my lord, it will boil down to this point that whether or not the board can be restored. Now, my lord, in terms of section 31, the life of a board is 5 years.
5 years.
So having been constituted on 28/8/22, it will, my lord, stretch up to 27. So, my lord, it is not
22. Is it 22?
22, my lord. Yes.
No,
28/8/22.
The board was constituted in 16.
No, it is on AGM election 28/8/22. AGM election was held for constitution of the board.
So having been constituted on 28/8/22, my lord, the validity of the board would, my lord, be up to 27. 20, 24, 25, 20, 27. 28/8/27. So therefore, the restoration was, my lord, within this period. It is not a case that it was restored beyond the time. So the challenge, my lord, in the writ petition is the restoration is bad. Now 41/6, my
No,
lord.
before we go to the restoration,
My lord.
restoration has been preceded by the constitution of the committee on 28/8/2022.
22.
Now this, what Mr. Sinha is contending, that this committee is been done as per a notice issued by the secretary
Yes, yes.
at page 31.
Page 30.
And he says that 41/6 has been violated.
Yes, yes, ma'am.
31.
And that is the reason why initially this was put on hold and one-man committee was.
Absolutely, my lord. In fact, the secretary, my lord, is the ex officio member of the board in terms of section 49.
Yes.
So therefore, my lord, if your lordship comes to the functions of the secretary, my lord, he is not, my lord, he is authorized to issue a notice with regard to the.
No, he is authorized,
My
but
lord.
you see, there is no dispute on 16/9/2016, the AGM was held, regular board of directors constituted.
Yes, my lord.
Correct? 16/9/16. So this expired in the year 2021.
My lord.
Now, if it expires and there was no move
Yes.
to hold the meeting, that 41/6 will come into operation.
Yes, correct.
And in this period, there was no one-man committee.
No, that cannot be. Because your lordship will see, my lord, there are only two options.
Yes.
Either it has to be run by the board
Mm.
or by the one-man committee.
Yes.
In absence
Now,
of.
what
my
is
lord-
41/6? Let us see.
Yes, in absence of a, my lord, one-man committee, the board cannot run, my lord. It has.
That is what we are trying to.
Yes, my lord. In fact, 41/6, my lord, makes it very clear. Now, in absence of a board, one-man committee comes in, my lord.
No, when the board fails to arrange for holding election before the expiry of the term of
Yes,
the board,
board.
number one, or delegates, or where
There are no
there are
direct-
no directors remaining on the board.
Yes.
Now, first, that the board did not arrange for holding an election and the term had expired in 2021.
One.
Under that circumstance, what will happen?
Yes,
A one-man committee will have to be constituted.
constituted.
There was no one-man committee.
No, it cannot be. There has to be one-man committee, my
No,
lord.
where was it?
No, the petitioner, my lord, has not brought on record.
No.
My lord,
No,
it is up to him.
Come to page 31. Page 31. What is page 31?
Yes. It is, my lord, by the secretary.
Yes, what is the contents?
My lord, page 32 is the vernacular. My lord, we can read 32. Because the entire part of the notice is not typed out.
Yes.
Yes. দীঘলী বহুমুখী সমবায় সমিতি লিমিটেড এত দ্বারা দীঘলী সমবায় সমিতির লিমিটেডের এর সভ্যগণকে জানানো যাইতেছে যে আগামী 28শে আগস্ট 22শে বেলা 11টা 11 সময় শ্রী অধীর রঞ্জন দাসের বাসগৃহে এই সমিতির ইংরেজি বার্ষিক সাধারণ সভা নিম্নলিখিত আলস্য অনুযায়ী অনুষ্ঠিত হবে উক্ত সভার আপনার উপস্থিতি কামনা করছে সমিতির সভার আলোচ্য সূচি সমিতির বিগত সভার কার্যবিবরণ পাঠ ও অনুমোদন সমিতির 21-22 সনের অডিটেড হিসাব ইংরাজি সনের প্রভিশনাল হিসাব নিকাশ আলোচনা ও গ্রহণ সমিতির 22-23 বর্ষের বাজেট আলোচনা ও গ্রহণ সমিতির 22-23 বর্ষের সমিতি ও সমিতির সভ্যদের ঊর্ধ্বতন
Now, this
বিল
is
গ্রহণের
marked to
ক্ষমতা
whom?
Yes.
This is marked to whom? Was it marked to a one-man committee? No.
No, my lord, it's not required. And 6, my lord, committee গঠন.
No, we want to know whether
Yes.
at this period when this notice was issued, we want to know the status of the board, whether it was being run
Yes.
by a one-man committee. It has to be. There is no other
Yes.
option.
Yes.
He is making out a case that there was no one-man committee. Suddenly, the secretary issues this notice. So the constitution of the board, wide order of 28/8/2022, is itself not in accordance with law. Therefore, the hold order, put on hold order 1/1/2024 was correct.
Yes.
It could not have been recalled.
Yes.
That is what we have understood from
My
Mr.
lord,
Sinha.
correct, my lord. My lord, with all respect,
But
my
we are more interested in having a duly constituted board.
my lord.
If it was not initially, it was not duly constituted. But to clinch the issue or to remove any doubts, we want to know the status, what has happened during the time when this notice was issued by the secretary
Right.
on page 31.
My lord.
Page 31 notice is dated what? 13/8/2022.
22.
Normally, Mr. Talukdar,
My lord.
just an information, if 41(6) comes into operation, the one-man committee comes into existence.
Right, correct.
Then thereafter also the AGM will have to be held, elections will have to be held. It is done by whom?
It is done by one-man committee. And-
We will just, that is what we have been noticing in all other cases. The one-man committee is interested to run and also hold the elections.
Yes.
Now, where is the role of where is the, I do not find the one-man committee at page 32.
That is correct, but what I'm on, my lord, the secretary, it is his duty to issue the notice, because only the notice has been, my lord, placed on record. Secretary issues the notice, my lord, there is no dispute on that. My learned friend, my lord,
Let's see the connecting averments.
Yes,
This is annexure what?
this is annexure 4, my lord.
Annexure 4.
Yes,
This is no BOD enters, no committee. Paragraph 5.
Yes, please.
Paragraph 5. What is your response? If Mr. Talukdar, you have
Yes.
filed affidavit.
We have filed affidavit, my lord.
What is your
Yes.
response?
My lord, if your lordship comes
Your
to,
R5.
my lord, this is filed on behalf of my lord, R2, my lord.
R2.
Yes, respondent 2. Now, if your lordship comes to page 126, my lord.
No, this is not working. Wait, wait.
Okay.
R2. You are R2, 132. Yes. What was the paragraph?
My lord, I was trying to draw your lordship's attention.
No,
that
no,
the
what
board-
was the paragraph which
Yes,
you just read?
Page 126, paragraph 5, my lord.
No, no, it's.
Roman 5.
Page is slightly different. This is 130, is not 126. Let us see. Just paragraph 5. What is your response to paragraph 5?
5, my lord, that the contention of the petitioner under 4, Roman 4 herein, that the term of the board expired on 15/9/21 is misplaced, inasmuch as there could be no cooperative society without a board at any given point of time, i.e., there has to be a board in a society, be it a democratic elected or an officer appointed under section 41(6) of the Act. Either there has to be an officer or a board. These are only the two options, my lord.
You just have to place on record that this election,
Yes.
Which was notified by the secretary, we may not be too much.
Yes, lordship is correct only to this.
13/8 for who has issued, but at whose instance it has been issued?
Precisely on this point, my lord, if I place the notification,
Yes.
the one-man committee, if one-man committee was
Yes,
running,
that is the issue.
yes, whether one-man committee was there or not.
That is
After,
the
my
issue.
lord, before 28/8/22.
Yes.
See, Rajesh Das, who's Rajesh Das? You are for Rajesh Das?
Yes, my lord.
How are you connected with this? You are on your membership. How is this impugned order passed in your petition? You asked for membership.
No, my lord.
Whether it's accepted or rejected, does nothing to do with the constitution of the board of directors.
My lord, my learned friend, my lord, the fact projected before this court.
You had questioned his locus. Now court is questioning your locus.
I am very impressed for my Lucas, my lord.
How are you connected to this? And why have you made him party?
He's this
That
result of appeal.
Imping order.
Imping order is.
At best a pro forma party. You have got no there's no connection of your cause of action, which you tried to espouse, with the constitution of the board of directors or restoration.
That is absolutely true, my lord.
Your case will be independently be considered. You are a co-opted member, your rights were limited, restricted. Now, if you want to be, a regular member, it will be considered in accordance with law. Mr. Talukdar, you bring that information, that will cleanse the issue. We are just interested to know whether after expiry of the term of the earlier board of directors, which was constituted on 16/9/16, it expired on 15/9/2021. After this, what has happened till the new board of directors? If it was constituted by a duly constituted one-man committee, we have nothing much to say, and it is restored now. As you have rightly said, term is 5 years. Unless something else is there, why should we?
Yes, correct.
It will run for 5 years.
Yes, lordship.
Okay. It's not a very big issue. Mr. Sinha has unnecessarily made the brief is so bulky, one will be afraid to take up the case.
Sorry, madam.
Huh? So,
Only the question is whether after 16/9/21.
we'll give you the order. The challenge in this petition is against an order dated 14/6/2024 passed by the Zonal Joint Registrar of Cooperative Societies, by which an earlier order dated 1/1/2024 of constitution of a one-man committee was withdrawn and the board of directors was restored. Full stop. Para. The primary contention, the primary ground of challenge is that the regular board of directors of the society in question was constituted in an AGM held on 16/9/2016, which had spent its force after expiry of the tenure of 5 years on 15/9/2021. Full stop. It is contended that after a sufficient gap on 13/9/2022, notice was issued by the secretary to hold the AGM, which was accordingly done on 28/8/2022. Full stop. The challenge is based on the factor that the constitution of the present board was not done in accordance with law, and there was violation of section 41(6) of the Assam Cooperative Societies Act 2007. Full stop. Para. To resolve the issue, it would be necessary for this court to be apprised regarding the status of the society after the expiry of the term of the earlier board of directors on 15/9/2021 till the new board of directors was constituted vide the AGM held on 28/8/2022. Full stop. In other words, this court is required to be apprised as to how section 41(6) was made operative during that period. Full stop.
Correct.
Sri Talukdar, the Land Standing Council, Cooperation Department, is accordingly directed to place on record, to obtain the necessary instructions and place the relevant documents before this court. Full stop. As pleadings have already been exchanged, the said instructions may not be required, but for the pleadings have already been exchanged. And not required, don't say anything. We fixed it when?
3-4 days, after 3-4 days, my lord, or a week, my lord.
List, on request, list on. Today is 19th. We can have it on 1st of September.
My lord.
My lord.
You get sufficient time, 1st of September.
The part time, my lord, captain.
Why part-time?
Yes, the thought you explanation, kindly, my lord.
Part-time, we may allow the petition. Don't take a chance.
Interim order passed earlier suspension.
What interim order?
Because that board, whatever the board they have constituted or they have taken resolution, that is stayed by this honorable court.
There was no interim order, my lord, in the main writ petition.
In the IA is
Even
there.
thereafter, after getting this interim order, my lord, illegally fishing there, my lord,
No,
they are taking
no.
advantage of this
Okay.
matter, my lord.
In the-
Several complaint laws against them.
No.
In the IA, my lord, a subsequent cause of action was brought in, my lord.
Yes.
The court was magnanimous
My
to grant a stay in the IA. Okay, interim order, if any, can extend it till the next date of listing.
Right.
Item 4.
For Mr. Chaudhary,
May please, Lordship. Now, in this case, my lord,
there is a private respondent, Mr. D. Deka. Where is he?
matter related to acquisition of land. The petitioner's land was acquired, my lord, in the year 2010, my lord, but compensation was not granted. So the similarly situated persons, my lord, they filed a writ petition. And in the writ petition, it was directed that inquiry will be held, and after that, my lord, they will do the needful, my lord. That order of the High Court.
Yes, who is for the respondent? Unopposed. Don't give Mr. Chaudhary a walkover. But we are interested in respondent number 7. Where is Mr. D. Deka? Who is D. Deka? Who is D. Deka, sir?
Apportionment.
Huh?
Apportionment. Apportionment. কথা সেইটো দিলে জি বলো
আছে নেকি কোন D. Deka কোন ফোন নাম্বার আছে নেকি পুরোনো ম্যাটার ঠিক করে বলে গেল 2020 ম্যাটার Damodar Deka neki. I think Damodar, who was the parent? Damodar Deka. Who?
No one appeared earlier, earlier date also.
Names are shown.
Names shown, but.
Asani, here is one number 6. Deep Jyoti Deka. Oh, Deep Jyoti Deka, yes. Who appears for Information Commission. Information Commission.
This is a matter, my lord, pertaining to apportionment. Because
I think his presence is only because the
Yes.
Information Commission is a party.
yes,
But who appears for, okay, oh, no, he appears for, Karkan appears. What's my number?
respondent 6 is, my lord, the state.
Oh, 6 may not be, but has 7 appeared, Mr. Chaudhary? Has,
Seven, my lord,
has 7 been served?
Yes, sir. It was served, my lord, and order has been passed, my lord, in this regard. As it was deemed to be complete, my lord.
Oh, 7 has been served. Okay, we can go ahead. 6 is not very essential. Yes,
Yes, my lord, here, yes, my lord, the petitioner purchased 2 plot of land, my lord. The in the year 1989 and one is in the year 2007, my lord. Then in the year 1989,
purchased.
He purchased 2 plot of land,
And
1989 and 2007, my lord. Those are annexer 1 and 2, my lord, the sale deed registered solely.
Purchased land. Okay.
Now, my lord, thereafter, my lord, this land, my lord, of the petitioner along with some similarly situated person was acquired by the government in the year 2010. But as no land compensation was granted, so they filed a writ petition in the year 2010, my lord, that your lordship will find it annexed 3, my lord. And this honorable court, my lord, by which order 10/8/2012, my lord, dispose of the writ petition, my lord, directing him to do a needful and make an.
Page.
My lord, it starts from page number 23, my lord.
2, 3.
Page number 23, relevant portion. Page number 31 and 32.
You filed 4/222 of 2010.
Yes, my lord.
Division bench. Right?
Came up before division. Thereafter, my lord, pursuant to that order, my lord, they passed that order, my lord, which order we are challenging, Annexure 4, my lord.
Now, what was the order and pay?
Order, my lord, page 31, relevant portion, my lord. Having regard to the nature of investigation made by this court, this will equip to the problem. This court is ill-equipped for the purpose, and thus the same has to be undertaken by the concerned revenue authorities and their office staff with affirmative association and the petitioners or their duly authorized representatives. In wake of the above, this represent dispose of with the following direction. The petitioner will submit a certified copy of this judgment and order with the Deputy Commissioner, Rural Kamrup, Amingaon, Guwahati, within a week here along with a copy of the pleadings of the parties and documents laid before this court. On receipt of the above documents, the Deputy Commissioner, Rural Amingaon, would cause an inquiry to be made into the petitioner's.
Okay,
claim.
to make an inquiry and take action in accordance with law. Okay,
Thereafter, my lord, this order was passed, my lord, that interim order, that is Annexure 4, my lord. So it was in respect of some persons along with me, my lord. My name appears in serial number 11 and 12, my lord. All these persons were not granted any compensation, and I was not also granted any compensation.
Your name? Harmohan?
Harmohan Nath, my lord, 11 and 12.
Payments, okay.
No.
Your claim could not be.
Thereafter, my lord, I obtained a Jamabandi, my lord. That's why I was not granted the compensation. Then I came to know that one of my mutation in respect of one land was cancelled, and in another land, the sale deed was said to be cancelled by the circle officer, my lord. My lord, it is in Annexure 5, page 35, my lord. In the comment section, comment portion, my lord.
Yes.
So thereafter, my lord, I made an application. that I
What
want-
is page 35?
Page 35 is a translated type copy of the Jamabandi, my lord. The Montebello part, remarks column.
One sale deed cancelled.
One sale deed cancelled.
Which sale deed?
My lord, the second sale deed, my lord,
2007.
2007 one. Sir, by circular.
And 1997, 1989?
The
What has happened that sale deed?
Mutation, my lord, mutation was granted, my lord. Mutation was granted and mutation was cancelled, my lord. Mutation was cancelled. So I made an application to know, file an RTI, my lord, to know on what basis my mutation was cancelled, my lord. But they could not supply me that information, my lord. And RTI appeal was also made, my lord, but the relevant information which I sought was never granted, given to me. And so I filed this writ petition. Thereafter, my lord, during the pendency of the writ petition, my lord.
What about the sale deed cancellation?
Daily cancellation, my lord, why they have cancelled it, it is not mentioned, clearly it is not mentioned, my lord.
No, you submitted RTI for both the sale deeds or for one?
Mainly for the
Mutation
plot of
cancellation.
land in which mutation was there, my lord.
There was no answer.
There was no answer.
You did not make any endeavors so far as cancellation of sale deed by the circle officer is concerned.
Circle officer, that was not sought, my lord.
Okay.
RTI application not
Okay,
sought.
okay.
Then thereafter, my lord, they file a affidavit, my lord. In their affidavit in opposition, my lord.
Who filed?
My lord, it is circle officer.
R4.
Circle officer filed.
R4.
Yes, my lord. As one not filed affidavit in opposition. In the affidavit in para 4, it stated that pursuant to some miscase number so and so, he has given miscase number so and so, and miscase that with regard to statement made in para 7 of the writ petition, the deponent beg to state that Sita mutation was rejected as per order on misapplication number so and so, and subsequently as per order on for the case number so and so, the mediation was cancelled, parenting or authentication of the registered shall be number dated so and so. Now, that order, thereafter, my lord, I again made an RTI application, my lord. Made an RTI application. And I have given my affidavit in reply, my lord. So I want to know, I want a copy of the order, my lord, by which my mutation was cancelled. But they could not supply me that copy of that order, my lord. And pursuant to order of the honorable court, my lord, now they have filed a new affidavit, my lord, stating that their record could not be found, my lord.
Yes, Mr. Circle Officer who is appearing.
Lordship. Prima facie, what it appears, my lord, lordship will see the affidavit, my lord, filed by the.
No, just a minute, just
Yes.
a minute. How have you verified? What is this new format? This verification has to be a part of the affidavit. It cannot be separately verified. The writ proceedings. Come to page 55. It ends at 54. Circle Officer affidavit. It starts at page 53. Filed on 2/4/2021. Mr. Borpudar, if you have a copy, kindly give it to your colleague.
মানে এখন কোন আছে এইখনত এইখনৰ মানে এই ভেৰিফিকেশ্যন পৰ্চন যে ভেৰিফিকেশ্যন পৰ্চন যে আমাক দিয়া নাছিলে মই লিখি দিছোঁ ভেৰিফিকেশ্যন পৰ্চন আমাক এখন পেজ দিয়া নাছিলে মই লিখি দিছোঁ
The verification cannot, there is no question of verification.
Yes, yes, yes.
It has to be a part of the affidavit itself.
Yes, yes. Right.
And
Yeah.
that is what we are trying to see. This is not in, you should have advised who had filed it. You have drafted it. Somebody might have done it on her own or his own. But you should have at least given the proper advice that this is not the way.
Yes, that is
A
correct.
pleading is exchanged in the file in the High Court. Even if you follow the CPC, there's an affidavit supporting the claim, supporting the written statement, there's a verification. Here it's, this whole thing is an affidavit. Cannot be another column for verification. The entire sacrosancy that reduces. Okay, but nonetheless, yes, what do you say? New affidavit was, what is it? New affidavit?
My lord, in my thereafter, my lord, we file the reply affidavit, my lord. In the reply affidavit, my lord, when we file we file an RTI application stating that since they have made an
Now they have said that the records are not there.
record is not missing, my lord.
Yes.
So when the mutation was cancelled, no notice was given. Circle officer has cancelled the, my lord.
How do you deal with this, resolve this kind of an issue?
Yes, yes, my lord.
We are not saying that he is above board, but he is trying to make out a case which needs a consideration. His projection may not be correct,
No, absolutely.
but
No,
we have come to a plan wherein prima facie is showing that he is backed by two deeds of 89 and 2007.
yes,
And the aspect of denying him of compensation is based on two action of yours, two background of yours. First, sale deed has been cancelled by the circle officer, whether the circle officer has the power to cancel the sale deed. Number two, which cell deed, of course, that question is not, he has not made an RTA. Mutation, he says that there is a miscase for cancellation. Miscase details we do not know. Who had instituted the miscase?
No, so therefore, my lord, if lordship may be pleased to come to page 33 of the writ petition.
Yes.
For a moment.
Yes.
Now, this is a, my lord, chart, my lord, the decision taken by the, my lord, Land Acquisition Authority, my lord.
Yes.
Precisely the collector,
Yes.
my lord, in pursuance of.
What is your name, Mr. Chaudhary?
Harmohan Nath, my lord.
Harmohan
At
Nath.
page 34.
Yes, yes.
11 and 12.
Yes, kindly see, my lord.
Yes.
11 and 12. Now, this exercise has been done in pursuance of the order passed by the Honorable Division Bench, which
Yes.
is available, my lord, from.
Yes, yes, we have
page
seen
20.
this.
Yes,
Yes.
my lord. Now, kindly see, my lord, serial number.
Okay, we'll come back at 2 o'clock. We'll come back.
Fine.
Right.
Okay.
Yes.
Lordship may kindly see, my lord, page 34.
Yes, we are at 34.
Yes, my lord. Serial number 11.
Yes.
As reported by Circle Officer NGC, now and then land compensation was.
NGC means?
My lord.
NGC means? NGC means?
NGC, my lord. Circle, Numoli Jola, not Guwahati Circle, not Guwahati Circle,
Okay.
NGC, not Guwahati Circle.
Mm.
As reported by Circle Officer, North Guwahati Circle, now and then land compensation was paid to Sri Kanak Nath, son of Joduram Nath, duly based on record. Now, so far as this aspect of the matter is concerned, they will have to lay a claim, my lord, which for apportionment of compensation under the Land Acquisition Act prevailing, which was, my lord, applied for acquiring that land. My second submission will be, my lord, at serial number 12, as stated by CO, the claimant's claim could not be established. Now, he says, my lord, petitioner alleges that, my lord, his mutation has been cancelled. If the mutation has been cancelled, my lord, it would be a issue of fact. Then he ought to have filed an appeal. Even if he is not having any documents, then also, my lord, stating everything, he can lay an appeal under 147 before the district commissioner. Because, my lord, factual aspects has to be gone into. So these are my basic submissions, my lord. Because his prayer in the writ petition is, my lord, at page 10, a writ in the nature of certiorari.
No, but that is okay, but will it amount to substantial justice? He says that he tried to take out the information regarding the mutation case, which has not been.
Now, my lord, in the affidavit, they say, my lord, that the records are not available. Now, if records are not available, then, my lord, he may.
Where are your seal deeds?
My lord, seal deeds.
Seal
Seal
deeds
deeds
are
next
there.
1 and 2, my lord.
Okay, so far as the other part is concerned, if you have a valid seal deed, why was it, what are the reasons?
Well, I don't know, my
See,
lord.
this page 34 is not an exercise which has been done very mechanically. It is an exercise done pursuant to a division bench order.
Yes, my lord.
So we assume, or you rather we presume that the factors have been taken into consideration. Yes, the reasons are not very adequate, but it is not only your claim which has been taken into consideration. We have found that the claim
All
of
the claims of
of
other parties.
13 numbers of claims have been taken into consideration, and all of the decisions taken have been given in the last column. So far your claim is concerned, there are 2 decisions because there are 2 claims. And these decisions, whether will you be left remediless? You can still stake a claim over this Kanak Nath, so far as apportionment is concerned. Kanak Nath is a party here, isn't he?
Kanak Nath is a
He has chosen not to appear. So you cannot have an enforcer have a decree from this court. You can have a decree from the civil court executed, even if it doesn't appear.
Yes.
But and so far as your sale deed is concerned, what has been said in the affidavit? Anything?
No, nothing has been said about it, my lord. Why it isn't cancelled? Nothing has been said, my lord. They have only mentioned that they could not, in the affidavit, my lord, at page number 54,
Yes.
they said that pursuant to an order passing through which case, the my lord, my mutation was cancelled.
No, not mutation. There are two issues. One is the mutation, the other is the
Sale deed.
sale deed.
The sale deed, regarding sale deed, they have stated nothing, my lord.
See, even in page 34, Mr. Borpujari,
Yes, my lord.
which is the mutation, which is the sale deed, Mr. Chaudhary?
My lord, so far, this, my lord, Konoknath concerned, Konoknath is the mutation, I think, my lord.
Mutation.
Because, yes, my lord, because I purchased the land from Juduram Nath, and Juduram Nath is the father of Konoknath, my lord. So in respect of this land, my lord, which I purchased in the year, I think 1989, in that plot of land, my mutation was granted. But later on, I applied for mutation in respect of the next land. But that sale deed was cancelled.
Your vendor was Jaduram Nath.
Yes, my lord.
And his son later on, he got it mutated in his own name.
My mutation was cancelled without informing me, and land compensation was given to his son, my lord. Private respondent number.
Now, was there a mutation ever in your name?
Mutation was there, my lord.
Where is it?
My lord, because this, my lord, it reflects from that, my lord, para 4, my lord. The para 4
of
page 54, my lord.
54.
Of the affidavit, my lord. There was Sita mutation, was rejected as per order of court. And then later, the mutation was cancelled, my lord.
Now, do you have the Jamamandi where your name was in fact,
Jamamandi, my lord,
in fact inserted as in the records of right?
That in page number, my lord, 35, my lord.
35.
35, my lord.
Yes.
Here is the, my lord, comment, my lord, in the commentary portion, my lord.
Sale deed mutation of
On dated 5/12/7, Hormone Nath is mutated in place of Jaduram Nath. Land measuring 3 Katha 9 Lesa. Over the right number so and so. According to Circle Officer order dated, actually it is 14/6/2010, mutation is cancelled in respect of land covered under KP Patta number 3232, bag number 546. In Moja Sila Sundri Rupa, village Sangsari, and one case was registered being so and so. According to Circle Officer order dated 13/11/2009, case number being so and so in respect of land measuring 3 Katha 9 Lesa, or right now probably, the registered sale deed number so and so is cancelled. So registered sale deed was also cancelled, my lord.
No, it's not like that. Covered by tag number, the name of Harmohan Nath, registered sale deed dated sales is the name. He doesn't have possess the power to cancel registered sale deed. It is only the mutation.
No, my here in the bottom portion, my lord, I think name of Hormone registered sale deed number so and so is cancelled.
We have found, my lord, that in the affidavit which lordship has seen, my lord, there was some error, my lord, incorporating verification. There, my lord, a document was sought to be annexed, Jamabandi copy enclosed. Perhaps it is not there in the case record, but in the office copy, my lord, that Jamabandi is there, my lord. Lordship can kindly see. This has been, my lord, erroneously filed, my lord.
Well, I said case number, sale deed of 89 was cancelled, my lord, not 2007. 89 was cancelled. First they granted mutation, then they cancelled the sale deed also.
Sale deed, my lord, Circle Officer don't have the jurisdiction to cancel a sale deed, my lord.
It is mentioned here, my lord. It is mentioned here.
Okay.
But I think this page 35, 36 is the vernacular. This is of which year? 2015. I think this This you could have challenged
Yes.
in an appropriate proceeding.
No,
Yes.
my lord, actually, we applied for the copy, my lord. I should get the copy, my lord, certified copy, so that I can file the appeal, my lord. How can I file the appeal, my lord? If I don't have any document, my lord. So I file RTI, my lord. So, and in the RTI also, they could not supply me any document, my lord. That is the problem, my lord. And now they have come before this honorable and saying that no record is there, my lord. So there is definitely some anomalies, my lord.
No, we will give you liberty to file this, but it is time barred. This is 2015.
2015. Therefore, my lord, if he
And in the order, will mention that in spite of your efforts, RTI even in the records have not been able to be granted. The authority which will decide will call for the records.
yes, that can be done. Yes, that's right.
You should not be burdened, because this perhaps will not be the forum to decide a dispute of this nature. I think that without that, I think no other relief can be granted to you. You'll be left nowhere.
Lordship
And
can
so far
provide
as
for-
your claim vis-a-vis the son of the other vendor is concerned,
Next, my lord.
against him, you can have to file a suit, I think.
Yes. Both ways also, my lord, he will have to, at the end of the day, he will have to file a suit,
Okay.
my lord. Because he will
But
have
firstly, my
to.
lord, I don't-
Okay, hold on. Because he will have to allege fraud, and fraud culminates from the date of knowledge. Lordship can make some observation thereby saving his limitation, my lord.
Heard.
Yeah, apparently it's a case of fraud.
I, Chaudhary, learned counsel for the petitioner. Also heard Sri S.S. Roy, learned state counsel, and Sri R. Borpujari, learned standing counsel, revenue department. Full stop. The instant writ petition has been filed with the following prayer put code, Para, as per the facts projected, the petitioner had purchased 2 plots of land in the years 1989 and 2007 respectively. Full stop. The said purchase was made duly while registered sale deed from the vendor who had the title. Full stop. The land, however, was acquired along with various other lands in the year 2010. Full stop. As the compensation was not paid, comma, you were there or not here?
Yes.
In 23, you are not there?
23, my lord.
Page 23, the writ petition, you are not there?
No, actually, we form an association, my lord. There-
No, it's not an association. One Nabo Kumar and Mufidur.
But pursuant to that order passed, my case was also considered, my lord.
Okay. Okay. Comma. A writ petition was filed by 2 persons who were members of an association of which the petitioner claims to be.
I am the brother of this son of Nath.
No. See,
No.
doesn't matter because he is the president of the Sangsharik Research Center. We are
Yes.
saying that
Navo Kumar Nath actually
was not paid. Our writ petition was filed in this court, being WPC 422 of 2010 by 2 persons claiming to be members of a society. Full stop. The petitioner also claims to be one of the members of the said society. Full stop. The aforesaid writ petition was disposed of by order dated 10/8/2012 by making an observation, by directing an inquiry to be made and thereafter to take appropriate action in accordance with law. Full stop. For ready reference, the directions given in the said order dated 10/8/2012 are expected herein below, page 31, huh? In the wake of FORPRA. At all again. Next page, next page, huh? Draw all two now. Pursuant to the aforesaid direction, an inquiry was made which culminated in an order dated 5/11/2013. Full stop. The grievance of the petitioner is that his claim for compensation has been rejected. Full stop. Para. Sri I. Chaudhary, the learned counsel for the petitioner, has submitted that so far as the plot of land covered by DAG number 546 and Patta number 232 is concerned, comma, the compensation was paid to one Sri Kanak Nath, within bracket respond number 7. Full stop. The claim for the plot of land covered by DAG number 611, Patta number 524 has been rejected with the observation that the claimant could not ascertain their rights as per the circle officer, New Guwahati Circle.
Not Guwahati.
No, not Guwahati Circle. Para. The I. Chaudhary, Sri Chaudhary, the learned counsel, has submitted that the aforesaid Sri Kanak Nath has been arrayed as a respond number 7 and has chosen not to contest this writ petition. He has informed that the said incumbent is the son of the vendor of the petitioner, and at no earlier instance, any notice was served upon him regarding the change of name in the records of right. Full stop. He has submitted that so far as the other plot of land is concerned, no details have been stated in the order, and accordingly, the petitioner had sought information by invoking the Right to Information Act. Full stop. However, no information could be given to him on the alleged ground that the records could not be traced out. Full stop. He has submitted that in the affidavit in opposition filed by the respondent number 4 on 4/2/2021, there is a mention of a miscase pursuant to which such change was made. Full stop. However, the details of such miscase have not been able to be stated in the affidavit, nor stated in the affidavit. The learned counsel accordingly submits that the present petition be allowed and the relief prayed for be granted. Per contra, Sri Borpujari, the learned standing counsel revenue, has submitted that the exercise carried out, which culminated in the order dated 5/11/2013, was after a direction of the Honorable Division Bench, and it can be presumed that all the relevant factors were taken into consideration. He has submitted that as many as 13 numbers of claims were examined and decisions taken by assigning reasons. Full stop. He has, however, been candid in submitting that so far as the claim for the plot of land, second plot of land under serial number 12 of the table the reasons are not elaborate, full stop. However, he submits that the rejection has been done as per a report by the circle officer, not Guwahati Circle, wherein it reflects that the claimant could not establish his claim. Full stop. He has also submitted that so far as the claim of the petitioner against serial number 11 is concerned, there is involvement of another incumbent within bracket respond number 7, against whom the petitioner would have a grievance. Full stop. He has submitted that in asserting such claim, the aspect of fraud may also come in. Full stop. As regards the denial of compensation, so far as the second plot is concerned, since it appears that there is an observation regarding the cancellation of sale deed, the same can be the subject matter of dispute in an appropriate civil proceedings. The aforesaid submissions made by the Learned Standing Council have also been endorsed by Sri Roy, the Learned State Council. Full stop. The cause of action sought to be espoused by the petitioner cannot be said to be without any basis. Full stop. At the same time, the question would arise as to whether the aforesaid cause of action can be raised in a writ proceeding which cannot adjudicate disputed questions of fact. Full stop. It appears that so far as the first claim is concerned, there would be a dispute with the respondent number 7, who is the son of the vendor. Full stop. As noted above, the said incumbent, though made a party in this proceeding, has chosen not to appear. Full stop. This court, in exercise of writ jurisdiction, cannot pass an order for apportionment of compensation for land acquisition without being apprised, as those are essentially questions of fact which are required to be established by adducing evidence in an appropriate proceeding. So far as the claim for the second plot is concerned, a submission is made that the duly registered sale deed has been cancelled by an authority, by an officer without any authority of law. Full stop. Both the aforesaid issues can be gone into by an appropriate civil court. Full stop. At this instance, Sri Chaudhary, the Learned Council, has raised a concern on the aspect of limitation. Full stop. As already observed in this order, the element of fraud would come in, and therefore the petitioner would be at liberty to make a contention that it is only from the date when the claim has been rejected that the cause of action has arisen. Full stop. The petitioner is also at liberty to take the benefit of Section 14 of the Limitation Act. Full stop. In view of the aforesaid discussion, this court disposes of this writ petition, however, by giving liberty to the petitioner to approach the appropriate civil court. Full stop. As mentioned above, civil court in the manner indicated above. Full stop. Both the writ petition stands disposed of. Sixteen to 42. Yes, some rejoinder has been filed today.
If the rejoinder has been filed, well, in person,
We
in
filed the
person.
rejoinder, my lord.
In person to my lord's last order, my lord, where, my lord, on 29/7/2025, my lord, a submission has been made, my lord, from the petitioner side.
Yes.
That some persons have already been settled and some persons are in the process of being given settlement, my lord, in connection with DAG number 97, though it is reserved for TB hospital. Under that circumstances, Lordship has directed us to file a consolidated affidavit.
Yes,
which
you have done.
We have filed it, my lord,
Yes.
bringing on record each and every material under what circumstances it was
Yes.
done, with all explanations. Thereafter, my lord, pursuant to that affidavit, few replies have been filed. My lord,
Yes.
2 has been filed today.
Hmm.
And my lord, as per Lordship direction in terms of the last order, we have summoned all the revenue officials from the district commissioner office. They're sitting outside, my lord, with all the records.
Okay.
Now, that is the state of affairs for the series today, my lord. Now,
No, when can it be done? We've rejoinder, we wanted to have a look at the rejoinder.
definitely, but, any date, my lord, then next week, my lord,
You tell us a date.
because this will require some time, my lord.
Yes,
We have
we'll,
to go
we'll, run-
individually.
we'll dedicate some.
My lord, my lord, my lord. Can it be on, my lord?
Pursuant to the order dated 29/7/2025, a consolidated affidavit has been filed by the Revenue Department and rejoinder affidavits have also been filed, comma, few of those have been done today, full stop. Para? Sri Varpujari, the learned standing council, Revenue Department has informed that the records pertaining to the issue have also been summoned, have also been obtained. Full stop, para? Considering that the pleadings have been, that the rejoinder has been filed, that few of the rejoinders have been filed today, even today, come on. The consideration of these matters are adjourned to
2028, my lord, can it be, my lord?
Second of September.
Huh?
2nd of September.
2nd September, okay, 2nd September.
2nd September.
2nd September.
To the exam.
2nd September. But don't leave in the last moment for filing any other.
Yes, yes,
I think
sir.
affidavits have been exchanged.
We have completed.
Completed, my lord. Somebody may turn up again, my lord, they
So
may file their reply, my lord, at the last moment again. Lordship may kindly fix the
It is
timeline, my
made
lord.
clear
Yes, my
that
lord.
in case further pleadings are to be exchanged,
My lord.
the same has to be done
Yes, my lord.
on or before
22nd, my lord, Friday,
on or before 26th of
26th, my lord.
26th of
My
September.
lord, my lord.
Tara, this will be vacated.
No, extended, maybe extended.
He has not said, he said there's an interim order. He stopped there. Interim order passed earlier, stands extended till the next date of listing. It's common order.
Come on, bless them.
Forty-three. Yes.
With regard to land compensation, my lord, and all the time, my lord, they assured before the honorable court that within short time this payment will be made. And my lord, all the time they are taking adjournment this way or that way, my lord.
Where is Mr. Chaliha? A. Chaliha had appeared on the last occasion. Who is appearing?
Last time Cholia was there. Earlier, B. Gogoi was there.
Content matter.
I'm giving you a call, my lord.
Yes, please call.
Yes, yes.
After a while, Mr. Chitra.
After some time.
After a while.
May I please your lordship, my lord? This is a case, my lord, where petitioner was prosecuted, my lord, twice for the same offense, my lord. 59 years. My lord, public prosecutor is not available. Your lordship, kindly come to the my
Why
lord.
is it there before this bench? Criminal
It's
matter.
a- Petition number 2 is an MLA, my lord.
So,
I don't know, my lord.
petition number 2 is an MLA, so it will come before this bench. What
Yes,
is
my
this?
lord, MLA minister case may be entrusted to your lordship, my lord.
Not like that. This is before a division bench, I think.
Lordship, what happened, my lord, in the instant? Repeat like everything. What happened in the instant case, my lord? What happened? In the, my lord, my lord,
Just a minute.
Yes, yes, sir.
Control criminal recording. Okay, now yes, who is there other side? So this is an assigned matter. Yes, that is what. PP, Mr. Parashar, you are there?
44, no? Oh. Scan copy স্ক্যান কপি দুইটা আছে তাৰমানে দুটা এটা কেছৰে তাৰমানে এটা ঘটনাৰ দুটা কেছ ফাইল কৰি দুখন চাৰ্জশিট ফাইল কৰি মইতো চেলেঞ্জ কৰিছোঁ 582 আৰু 46
But actually fact is that I was in other court that I have hurriedly come, I have not yet gone through the scan copy also.
Okay, well, Mr. Chaudhary, some other day, which you are protected by an interim order.
Yes, sir.
Okay, yes, while Sri NNB Chaudhary, learned counsel is present for the petitioner, comma, Sri KK Parashar, learned APP, has paid for some accommodation, para? When? List after 2 weeks.
Yes, sir.
List after 2 weeks. Should we fix a date?
As your lordship like.
List after 2 weeks, interim order passed earlier to continue till the next date of listing.
Swapna.
But next date, come prepared.
My lord, and the IA has been filed by the other side under 17B. My lord, this stay order was passed after hearing everybody. I pray, my lord, the whole matter should be thrashed out.
No, 17B will do, will pass
No,
on.
my lord, it is not a simpliciter case. What had happened, my lord, the petitioner before your lordships, my lord, they were onto manufacturing razors, my lord.
Okay. Okay.
They were actually manufacturing safety razor blades, razors, etc.
Okay.
There was a business transfer agreement, my lord, between the petitioner company and another company whereby and whereunder the everything was transferred, including the litigations. Now, my lord, there is a direction for reinstatement. My lord, who will implement that order? The transferring company. I am the transferor. How can 17B be maintainable against me? I appreciate, my lord. 17B, it's mandatory nature, everything. Now, for example, if
Let
a
us
law-
see the award.
Yes, I'm coming to event. I'm coming to the award. Please come to my lord. No, very order book. Please come to page number, my lord, 167.
The award is at 154, isn't it?
Yes, yes. No, prior to that, my lord, the orders were passed by the Labor Court Thane, my lord.
Yes, that is it, 154.
Please come to page 167. Yes, it starts at 154. Yes.
page 167, line somewhere in the middle, my lord, the second party is served by widow. As a lobster's copy, my lord. Having regard to 3 years of service.
Yes.
Yes. Having regard to
167.
3 years of service of the second party, lump sum compensation amount of rupees 2 lakh in lieu of back wages would be appropriate relief to the widow of the second party. Now, this is important. First party number 1, that is the petitioner, transferred its business to first party number 2 on 30th December 2010. Copy of the relevant part of the concerned business transfer agreement is filed on record. It reveals that in disclosure part, contingent liabilities are mentioned, and therein a reference of the present litigation has come. First party number 2 has not disputed this part of the business transfer agreement, nor lead to any contrary evidence. Thus, first party number 2 is under obligation to compensation amount of rupees so and so rupees to the widow of the second party. Thus, issue number 3 is answered in the affirmative.
Yes.
Already there is a direction, my lord.
No,
Then, my lord,
where is the direction for reinstatement?
yes. Page 111, my lord. This is the award.
111.
Yes, 111, sir. And operative portion is at page number 127. Page 127.
Yes.
So I have decided issue number 1 against the management. At the same time, in view of the decision in preliminary issue number 1, 2, and 3, and issue number 1 of the reference case in view of the decision thereon, I hold that the workmen are entitled to reinstatement with full back wages. If they are not in service, monetary benefits shall be given till their resignation from the date of dismissal on so and so. And if anybody is still living idle, he is to bear or they are to be reinstated forthwith with back wages. If by this time they are not in service of the company, the monetary benefits shall be given. And my lord, I will just draw your lordship.
How many workmen were there?
Two workmen. If a lordship would kindly come to.
This is by the Labour Code Guwahati.
Yes.
This is the original award.
Yes.
Now, how come Thane had a jurisdiction? What was it?
Now, if a lordship would kindly come to page 169 for a moment, my lord.
169.
No, sorry, 192. It would be order. 192.
Yes.
Now, this is a part of the award passed by the Labour Court at Thane, my lord. Earlier was in reference IDA number 360. Now it is under ULP number 7 of 2008, para 40.
Yes.
Perusing the entire business transfer agreement as well as the disclosure letter, which forms part of the business transfer agreement, it appears that transferee, that is respondent number 3, that is the transferee company, are now liable for fulfillment of all their business liabilities with effect from the transfer date. As stated above, business liabilities also include contingent liabilities. Learned advocate for the complainant has drawn my attention to Schedule 4 of the disclosure letter pertaining to contingent litigation liabilities of respondent number 1, which are now transferred to respondent number 3, that is Supermax Personal Care Limited, that is the transferee company. From the same, it appears that at serial number 25, this present complainant, that is complainant ULP number so and so, between Dinesh Tiwari and Bidut Metallics Private Limited, and contingent liability of rupees 1,90,000 so and so is mentioned therein. The contingent liability is, however, as on the date of business transfer agreement, that is 30/12/2010. However, the court cannot limit the respondent's liability only on the said amount. It is an admitted position that respondent number 3 has taken over all the liabilities, and thus they are well aware of the same, and it is at the time of the business transfer agreement. Present complaint is decided on the date of the judgment. Therefore, as per the business transfer agreement, it is respondent number 3 who is liable and responsible to comply with the relief granted to the complainant. So how we can be fastened with the liability, my lord?
What is your case?
Lordship, this just
IA for what?
IA for under section 17B. Lordship,
IA number? Two IAs.
yes, two IA and two responding. Lordship, this just the learned serious senior counsel has read out.
Just a minute. Let us understand your case. What is, Mr. Chaudhary, I think you have missed out one point. Sorry.
Sorry, madam.
Please, I think you have missed out. The award is not the part of challenge. You are challenging 32C2 proceedings.
Yes.
So where will be 17B applicable?
Basically, award, the execution process is stayed and award is also under challenge.
Where?
Lordship, I may be allowed to read out the award, page 22.
Challenge হয়. No, we have challenged the award, my lord, consequentially.
Okay. What is the stay?
Execution process is stayed.
What is the stay? Stay is what? Stay is the award stayed?
Yes, award and execution. Execution of the award is stayed.
That means
How do
33
you
C2
exec-
proceeding.
How do you execute awards?
Under section 33C2.
No. That
That
is
is a calculation.
That's a different matter.
Lordship,
We have not read the idea. No idea.
yes,
That is not how you execute awards.
section 33C2. It
Sorry,
will take-
Mr. Mukund.
Lordship, I may be allowed to submit, I will satisfy the court.
It's not a question of satisfaction.
No, yes.
You are not on the correct provision of law.
No, this is the.
Mr.
The problem-
There is no problem in deliberating. You should have the patience to hear also.
Yes,
We know something about this act.
Lordship, sure.
Come to section 11.
Section subsection 9.
8 first, then 9.
Page number 28.
So first we read 8, then 9. What is the labor code? What is the
Yes.
status of a labor code? Please read.
Filing of vacancies.
No. The act of 1947.
Yes, I have, but
Not filling of vacancies.
this
11.
11.
11, 8 and 9. First read 8, then you come to 9.
I'm reading the 8.
8.
If for any reason.
No.
This
What are you having?
finality of orders constitute.
11. Procedure and power of conciliation officers, board, court,
Yes,
and
yes.
tribunals.
11 describes about the power and function of the
Yes,
court.
8, subsection 8. 11, 8.
Eight. Every labor court, tribunal or national tribunal shall be deemed to be civil court for the purpose of section 345.
Of the code of
346.
criminal procedure. Then come to 9.
Every award made, order issued or settlement arrived at by or before the labor court or tribunal, national tribunal shall be executed in accordance with the procedure laid down for execution order in a civil court.
Okay.
That is true. But before
The
that,
second question,
Yes.
the stay order has not stayed the award.
Lordship, stay order has
No,
not stayed.
no, you have to go by 17B. What is 17B?
17.
If an award of reinstatement is stayed, then it is 33C2 is only computation.
Probably it is, if it is put under challenge, then also I am entitled.
No. It has to be stayed. Where is the stay? You go for execution.
No,
Set on there.
I may be allowed to read out the section 17B.
Yes, please read.
Where any case, a labor court, tribunal or national tribunal by its award directs restatement of any workman and the employer prefers any proceeding against such award in a high court or the Supreme Court, the employer shall be liable to pay such workmen during the period of pendency of such proceedings in the High Court or Supreme Court full wages last drawn by him inclusive of any maintenance allowance admissible to him under any rule if the workman had not been employed in any establishment during such period and an affidavit by such workman had been filed to that effect in such court, provided that where it proves that the satisfaction of the High Court or the Supreme Court that the workman has been employed and had been receiving adequate remuneration during any such period or part thereof, the court shall order that no wages shall be payable under this section for such period or part as the case may be. Well, it is clear that if it is put under challenge, then also I am entitled.
But is your avenue for executing the award been
No, Lordship, one
closed?
thing is that, Lordship, I'm sorry, I'm interfering. That under section 33C is not the execution process.
Yes.
It is an computation of the amount of money which I am entitled to receive. First, the labor court will calculate the amount, then I will go for the execution. Until or unless the amount is not calculated by the court.
See, don't mix up 33C2 with the direction for reinstatement.
Yes.
17B is only for reinstatement.
Yes, yes.
If you are not reinstated only on the pretext that a case is pending in the High Court or Supreme Court, can you be left like that, a workman? So this 17B is only to facilitate that you can have the means to contest. You will be given the last wages drawn.
Yes.
It is only for reinstatement, not for any money amount. Money has to be
yes,
33C2
that
is
a
open to
very
you.
Two part, Lordship is correct. I am not on that. But it is the writ petitioner who has mixed up the two parts. They have challenged the order which is.
Now, if you see that the interim order is only the proceedings of the under 33C2.
That is true, Lordship. I am not disputing. But
You
I am purely on
initiated an
the.
execution proceeding, that is one.
I am
Or
purely
otherwise,
on
if
the-
you are agreeable, we can have this writ petition finally heard.
No, Lordship, I am purely on the section 17B. Lordship, it mandates that if any award where the direction is given to restrain the workman, then also if it is put under challenge, then during the proceedings of the challenge, I am entitled. It is the clear mandate of the law.
Suppose they withdraw the writ petition today.
They let
Suppose, let us assume they withdraw the writ petition today. Then what do you do?
Now, if they withdraw the writ petition, then I will
Then
go
what do you
for
do?
then I will follow the step of the law as directed.
No, you can contest the 33C2 proceeding, but at the same time, for reinstatement part, you have to file for an execution.
That I'll go. That Lordship,
So this-
because the execution
This
process.
filing, I think without reading into the aspect of whether there is an interim order pending, will it have any meaning?
Lordship, this order, restatement along with the back wages, there are two parts. There is back wages has to be calculated first. If I go for the execution, then I will not
No,
file a
that
two
is a
separate
different
litigation.
aspect. You filing an application. You are filing an application for vacating the interim order. That's a different aspect. We can examine that whether the proceedings under 33C2 should be stayed or not. We can examine. That's a different aspect. But if you are insisting that 17B has to be should be applied, then the matter would have to be differently
Lordship,
considered.
for the moment, I am forgetting about the 33C, but I am just on the mandate of the section 17B. What does it say? It says that if the award is put under challenge, then also I am entitled. Lordship may peruse the section 17B.
You are responsible for 4 and 5.
Yes, Lordship.
Okay. Your reinstatement has been directed by the award.
Yes, Lordship.
What was your nature of employment?
Sales personnel, Lordship.
You fall under workmen.
Yes.
Mr. Chaudhary, what do you say? If you go by the wordings, you
Lord,
may be,
no, Lordship is correct.
but we have to give a meaning to this.
Yes, yes.
Whether simple filing would be,
Lord, my humble submission is, my Lord, there are issues to be gone into. Let me also come fully prepared, my Lord. Also, will give an early date since it's a matter which, I mean, merits consideration in early stage, my Lord, so that I can also assist your Lordship properly. my Lord.
no, see, there will be two entirely distinct
One-
aspects.
One problem which my learned friend has not pointed out, he had filed a, my Lord, execution petition, and he had withdrawn it on the ground that he came to know that Supermix is to make the payment. Sorry, it was to implement the order. We have a next, my Lord. He filed an execution case and he withdrew. And in the withdrawal petition, my Lord, they has clearly stated that it is the Supermax who is required to implement the order. That's why I said, my Lord, also will fix an early date. I'll assist
No, we
you.
can have the entire writ petition
Yes.
also,
Yes,
Lordship,
because we do not want workmen to be suffering.
exactly. Any date, my Lord.
one more thing, last submission.
I think my learned friend will also go through the law properly, my Lord, so that he can also assist your lordships properly.
I'll follow the suggestion.
No, see, in the writ petition, he may be correct in contending that both the award as well as the 33C2 proceedings have been amalgamated in the challenge.
Yes, that we have
You have
done.
also challenged the award, you have also challenged the proceeding, because 33C2 arises from the award.
Yes.
Award
That
is
is
the
correct.
award
To
is
that
the
extent,
basis
it is correct.
for that competition, for the back wages, everything. Now, competition of back wages is one aspect, reinstatement is the other aspect.
Totally different.
Third, restatement 17B may come in, and he's trying to make out a case that in spite of the fact that whether stay is there or not, the moment you file, you may have to, he may be correct, because the wordings, we have to again relook, take your assistance. There is no
fetter.
No condition that unless,
yes,
if
no
it is
fetter.
stayed, if it is stayed, nothing like that. The moment you file, you have to pay. But I think there would be some case law.
That's why, my Lord.
There are cases
Lordship
that,
will fix it at an early date, my Lord. We'll do the hearing.
Lordship, one
because
more-
if there is no stay on the award, there is no restriction for him to go for execution.
Exactly. That he did at the withdrawn.
One thing is that I may go. Lordship, I'm before the, standing before the Lordship, and as I'm guided by the
Okay,
ID Act.
Okay, let's have a date of your concern.
Yes.
One more last submission.
Yes.
Lordship, that the business transfer agreement, which they are relying, it was not placed before the labor court.
Okay.
And the law is well settled that that the plea which was not introduced before the labor court, it cannot be introduced in the writ court. Lordship, one thing is that Lordship is exercising while adjudicating the writ petition challenging the award passed by the labor court. Lordship is exercising jurisdiction under 227 of the Constitution of India. So Lordship will examine whether the award is passed, lack or access jurisdiction, failure to exercise jurisdiction, or findings not based on the evidence at all. These are the 3 points Lordship will examine. Here they are relying on the documents which has never been exhibited in the labor court. So Lordship, this document, and I'll place certain case law also, under such circumstances, Supreme Court candidly says that no new document can be introduced in the writ court. And the reference which is given in.
You're correct. We are only examining the decision-making
My Lord
process.
can have it on second, my Lord, if it's convenient to my learned friend.
2nd of September.
September, yes. my Lord.
Yes, it can be done.
Yes.
2nd is a Tuesday.
Tuesday.
But whole writ petition.
Yes, hold it, petition.
And Lordship, it may be taken for disposal.
Of
Whole
course.
writ petition.
Lordship,
Okay.
Lordship.
Heard,
My Lord, 2-3 aspects I also need to, my Lord, go into.
heard Sri K.N. Chaudhary, Run Senior Counsel for the writ petitioner, assisted by Sri S. Chakraborty. Also heard Sri Mazumdar, L.R. Mazumdar Learned Counsel for the respondent, contesting private respondents,
Yes.
Lordship.
who has also
4
filed,
and 5.
who have also filed 2 separate interlocutory applications. Para, after hearing the Learned Counsel. No. The Learned Counsel for the Learned Senior Counsel for the petitioner has submitted that the entire issue can be taken up for final disposal. Full stop. Considering that the private respondents are workmen who, in whose favor an award was passed, which is a subject matter of challenge along with the proceedings under section 33C2 of the ID Act 1947, list for admission hearing on 2nd of September 2025, full stop. On that day, an endeavor would be made to dispose of the writ.
Lordship.
Deeply obliged.
Yes.
My lord, in this case, my lord, the
Yes,
account,
yes, we had heard this matter sometime.
it has been.
What was
class-
this?
It has been classified as NPA, my lord, although we have paid within the time period of 90 days. My lord, to fortify my argument, my lord, I have filed an affidavit which has not come yet, my lord. So.
When did you file? Today?
Yesterday. my lord.
Yesterday, your lordship. I had-
Served on you or
Yes,
not?
we have served to him.
Yes.
Okay, we'll have it when?
As convenient. to him.
Wednesday next.
Friday, my lord.
Friday, this court will rise early.
Then, my lord, any day convenient to your lordship.
No? Wednesday next. Okay.
Lord, your lordship.
As
is already-
Dr. Leonard Senior Counsel has submitted that an additional affidavit has been filed yesterday, which however has not been tagged with the records. Para 3 M. Sharma Leonard Counsel for the respondent bank has expressed urgency. You are for whom?
Question number 2, Lordship.
Who is
Reserve
two?
Bank of India. 46.
Who is two?
Reserve Bank.
Reserve Bank.
Okay. Your name, please?
This is Bora on behalf of P. Hazarika.
P. Hazarika, H.S. Bora, Leonard Counsel, appearing on instruction of Sri P. Hazarika, Standing Counsel, RBI is present. Para, as agreed upon, list on Wednesday. 27th.
Lord, your lordship has already protected us so that the physical possession cannot be taken.
Oh, interim order passed earlier to continue till the next date of listing.
Obviously.
Your lordship, it is an affidavit, not an additional affidavit.
No, it's an affidavit.
Additional affidavit.
छोटा मोटा बात क्या पड़ा छोटा मोटा बात क्या पड़ा नहीं ऑर्डर में आ गया
It's regarding payment of a land acquisition amount, my lord.
Yes, yes.
My lord, so far as the amount is concerned, finance has sanctioned it. Within a, my lord, period of 1 week or so, it will be deposited in account of the petitioner. That process is on.
No, Mr. Chetri is saying that it is going on for quite some time.
No, no, there is my latest instruction, my lord. Now the amount will be deposited, my lord, to the account of the petitioner. Only 2 weeks, my lord,
Okay,
let
hard
it by,
three
within
weeks,
this week,
three-
it may be deposited.
Leonard Counsel for the petitioner. Para 3. B. Gogoi, the understanding counsel finance department has however submitted that as per the
Health,
latest instructions.
health.
Or health.
Right.
And that as per the latest instructions received, the amount, the process is at the verge of completion.
Yes.
And the amount would be deposited in the account of the petitioner within a period of a week.
One. Well,
Para, list this case after 2 weeks.
my lord, lordship will fix that.
2 weeks, by that time, I think you will withdraw.
He will withdraw, my lord, yes. That is my latest instruction, my lord. It will withdraw.
Yes, next.
Obliged, lord.
48, item 48.
Yes, 15 matter. Some mention was made in the morning, but we are not very inclined to, because it's a matter of 15. What is the matter?
The matter regarding issue is this, my lord. I had a land, my lord. It was in 1991, my lord. It was auction, my lord. That into, according to me, my lord, it was confirmed in 1992.
Now, auction for what? Non-payment of revenue?
Yes, yes.
Okay, then.
2007, I came to know
Okay.
regarding this. Accordingly, I filed an objection. So nothing happened. So accordingly, I approached the Learned Board of Revenue. my lord. Board of Revenue, whatever the delay and the hearing clubbed together and allowed by petition, my lord. Appeal, my lord. Against that, they approached the Honorable Guwahati. Honorable Guwahati remanded back on the ground that the delay application has to be heard separately at first.
Okay.
After that only, appeal shall be heard. At that time, my lord, on delay point, my lord, our case has been dismissed, my lord.
You are challenging that part.
Yes.
The second decision of the Board of Revenue.
Yes, my lord. Against that, my lord, we have approached this.
Who are you?
Lordship, respondent number 8, Lordship.
Is the auction to purchaser or what?
Yes, I think.
Respondent number 8 is the main particular.
Yes, that is the issue. My lord, impute order reflected, discussed something that in 1994 we came to know That was on record, my lord, but those were not on record, my lord. In order sheet wrongly reflected, my lord. We never submitted an application in 1994. That record is also not there. And this order sheet,
We would like to remand this matter back for adjudication on merits.
yes, my lord, yes, that is the case.
And the board will not be affected or impacted by the first decision, which was in your favor.
My lord, yes, yes.
I
yes.
think, but when is Mr. Hazarika, when is he coming back?
Any day on next week, Lordship.
Okay. Heard 3A Chaudhary, Learned Counsel for the petitioners. Also, however, a prayer for adjournment has been sought for on behalf of 3TA Chaudharika, Learned Counsel for the substituted respondents for respondent number 8. Para. As this matter is pending since the year 2015, a short accommodation is granted directing listing of this matter on (28) to 8.
Obliged. Obliged.
Yes, what is this?
My lord, wait, please. My lord, this is the, my lord, challenge to the Provident Fund order, my lord, as well as the notice of recovery. There was a stay order operating, my lord.
Yes, madam. 15 matter. Yes, what is it?
My lord, this page 62 was the order, my lord.
Narrate the facts. It's for hearing. We'll dispose this of 15 matter.
Lordship will take it up for disposal. Lord.
Yes, yes. Hearing.
Yes.
2015 matter.
Then,
What is it? Who are you?
My lord, may I narrate the facts, my lord?
Please.
My lord, earlier, my lord, we filed a writ petition, my lord. That writ petition order was here, my lord. We have already annexed. Page 35, my lord. The earlier we have challenged the notice of demand, my lord, which was issued to us, my lord, without determining the jurisdiction, whether the teaching tuition is a, my lord, is a regular nature of business or not. Now, on pursuant to that honorable court order, your lordship will find at page 35, my lord.
35.
35, annexure F. Order dated 18/6/2015, my lord. And your lordship will find page 36. Paragraph, last portion of para, having regard. I'll read from page 36, second.
Yes.
Yes.
Having regard.
My lord, I read from the first paragraph. The petitioner is aggrieved by the annexure is so and so dated 26 May 2015 of the recovery officer, Employees Provident Fund Organization, by the said notice terming the petitioner as a defaulter, a demand has been made to pay rupees so and so for the period from April 1999 to March 2004. That was the initial, my lord. The demand so made is in respect of the Employees Provident Fund as per provision of the EPF and Miscellaneous Provision Act. Petitioner has urged various grounds so as to contend that he is not liable to pay the amount. On perusal of the impugned notice dated 26 May 2015, it appears that the demand so made is pursuant to a certificate dated 26 May 2015 of the authorized officer so and so for the recovery of the amount, details of which are also indicated in the impugned notice.
Having regard to the nature of the grievance raised, the writ petition is disposed of the motion stage itself, granting liberty to the petitioner to approach the authority issuing the notice dated 26 May 2015, agitating his grievance as has been agitated in this writ petition. In the event of such approach being made within a period of so and so, the said authority shall dispose of the matter by passing a speaking order, my lord, as expeditiously as possible within 15 days. So, pursuant to that, my lord, your lordship will kindly see, and page 38, my lord, the representation was made before the recovery officer, my lord, of the appeal. Now, your lordship will find, my lord, the page 62 is the order, my lord. So page 62 is annexure I, my lord. Now, this order has been passed by the recovery officer, my lord, in compliance of the Honorable High Court order, my lord. But, my lord, in this order, my lord, the lordship, the jurisdictional aspect which the court has referred to has not been discussed. Rather, my lord, may I read the, my lord, last page 69. What the authority has done, my lord, is very surprising, my lord. For the reason discussed above, the grounds taken by the petitioner establishment in the present writ petition for assailing the impugned letter and orders are not maintainable in the eye of law. Accordingly, writ petition is devoid of any merit and liable to be dismissed. So he has disposed of the, my lord, writ petition, my lord. Kindly see, my lord. Accordingly, the writ petition is page 69, man. Last page. The issue relevant to the jurisdiction has not been decided, rather dispose of the writ petition by saying that writ petition is devoid of any merit and liable to be dismissed. Now your lordship will come.
No, that is obviously incorrect, but you have to,
Incorrect.
you have to read the entire order as such. What is there in the observations in the
Observation,
earlier
my
part
lord.
of the order?
The issue that has been, we are raising, my lord, the jurisdiction, whether the establishment that we are, my lord, concerned, my lord, whether it comes under the Employees Provident Fund or not. Your lordship will kindly come to paragraph 3 and 4 of my writ petition. Paragraph 3 and 4, my lord. Paragraph 2, 3 and 4, my lord. Because some issues are there, my lord, factual speak. Paragraph 2, my lord, page 6, my lord. Kindly see, my lord, this proprietor Srimati Fuleshwari Gogoi, she started a private teaching center, my lord.
No, but okay, but these factual aspects which you are raising, which we have raised in your representation,
Yes.
those have been taken into consideration by the impugned order.
Not taken, my lord. The main jurisdictional aspect, my lord. Whether the private teaching center is an establishment or not, because the act gives jurisdiction only if it comes within the definition, my lord. And that has to be decided as per our Supreme Court judgment, my lord, Hariharan. We have referred to that also.
No, but what about page 64, last part, and 65? There is a clear finding that it is amply clear that the petitioner fulfills the condition of so and so, so the petitioner has rightly been covered. And prior to that, at 65, subparagraph 3, central government-wide notification applies to educational, scientific, research and training institutions.
That is regarding educational, scientific research and training institute.
Yes.
Our is a tuition center, my lord. Whether the tuition center comes
But it
within
is
the...
a Gyan, how many students are there?
It was, now this school is no more, my lord. It was, they have issued the demand notice after 15 years, my lord. The school was a, my lord, tuition center in the year 1999. And there were only 23 employees, teachers who have joined on honorarium, my lord. On the condition that as and when they will get better scope, they will leave and join. Out of 23, my lord, 5 of them, my lord, your lordship will appreciate, 5 of the then employees, my lord, teaching staff, 5 of the employed accepted to provide their provident fund. But the authority, while that time, my lord, I have narrated, did not accept that 5 of them cannot, they did not provide the account number and all the details by the prescribed form. They did not provide, my lord, that the 5 of the employee cannot deposit. Now that was a condition, my lord. It was for the class 1 to 4 and for KG and playgroup. So, my lord, there was no appointment letter, no pay scale, or no salary, my lord. It was just an honorarium we have stated before the authority of the recovery officer. Now, your lordship, in the year 1999, your lordship will find in the year 1999, this notice was issued by one enforcement officer, my lord, all of a sudden, my lord, annexing the list of these 20 employees. That list, your lordship will
Yes,
find.
what do you say, madam? That his
Law.
primary contention is that there is no determination
Under
whether
the-
a tuition center would come under the ambit of your action.
Lordship, the notification itself is there, which covers including the private institutions also, and it is also in the act also, Lordship.
No, private is, but he's called, it's a tuition center. He's trying to
Teaching-
differentiate between a normal educational institution and a tuition center.
That aspect, Lordship, has been stated that the notification covers this, your Lordship. This one,
Have you filed your affidavit?
affidavit has been filed long back, your Lordship. I have been given last month with a brief, your Lordship.
The affidavit does not have the
It is
notification.
complete at that time.
What is this notification?
In this notification, your Lordship, it has been stated, that is also in our affidavit also, your Lordship may kindly peruse. Paragraph,
Will this be enough? Any university, any college, whether or not affiliated to a university, any school, whether or not recognized or aided by the central, any scientific institution, any institution in which research is
Yes.
survey activity of,
12 we have mentioned, your Lordship, of our affidavit.
yes.
That with regard to statement and para so and so, the Ministry of Labour, Government of India, by notification number SO 986 dated 19 to 1982,
Para 12.
para 12 of our affidavit, your Lordship.
Para 12, is it there? In opposition by 1 to 4.
Yes, your Lordship.
There is no para 12. Oh, yes, you are correct. Correct, para 12 is there.
Notification number SO 986 dated 19 to 1982, published in Part 2, Section 3, Subsection 2 of the Gazette of India dated 6/3/1982, brought all the educational, scientific, research, training institute under the purview of the Act, wherein Jyoti Vidyapit is an establishment falling under this category. Hence,
Okay, you have the act with you. Let us see the act. What are the subheadings? Please read. There are 6 subheadings.
Lordship may peruse the scheme, page number 68 of the Act.
68 of
In
what?
the Act, your Lordship. Section 9, it is in
Para?
Schedule 2. That is, as per my book, it is page number,
You are referring to the Employees Provident Fund
scheme. 19.
This one?
Yes,
52.
yes, scheme, page number 68.
68 is what?
68, and the first, second para, your Lordship. And respect of educational, scientific, research, training institute specified in the notification of the Government of India, so and so, published.
No, we have seen this notification. You have placed this notification. You need not go to the schedule of the act. Notification is before us. You read the notification. That is an extract of the notification only.
Yes, Your
Please read number 1 and university.
Lordship, page number.
Notification.
Okay.
You have an extra copy? Do not have. Well,
Yeah.
well, you can have an extra copy. Put it in it. All different page. All different page. लेकिन ये पेज ये टू पेज ले जस्ट मैं चुता कॉपी कर रही
I have your lordship.
You have? Oh,
Yes.
just you don't get it.
An university, any college, whether or not affiliated, any school, whether or not recognized, aided by the central or state, any scientific institution, any institution in which research in respect of any matter is carried on, any other institution in which the activity in respect of
Activity of imparting knowledge or training is systematically carried out. He will come under which one?
It will come as a what has been stated in para 2 of the writ petition. In the writ petition, your lordship.
Now, why do you go to the writ petition? We know it's a tuition center. Under which head it will come?
Private teaching center. Private teaching.
Which head?
Lordship?
Which head of this notification of 82?
Yes, it is not here, but they have stated in their writ petition, your lord.
It's a private tuition center.
Yes,
Tuition center.
teaching center. Your lord.
Teaching center. It's not a school, it's not an university, it is not a scientific institution. So it has to come within the ambit of the notification of 1982.
Lordship, my suggestion will be, can it be remanded back for a fresh?
No, my lord, your lordship will kindly come to my paragraph 19, my
With
lord.
this jurisdiction, if it is not decided,
It is, my lord, your lordship will kindly appreciate paragraph 19, page 18. my lord,
because
for the-
more than 20 employees, which is covered.
This was closed down long time back.
Long time, my lord, and after 15 years, they have issued, my lord.
Covered, no,
Without
lordship,
deciding.
in between 23 numbers of notices were sent and proceeding ex parte carried on, your lordship.
There is no record.
That aspect we may not, we
No
may be with you.
That referred in.
Because
David.
he's a government, but under which head it will come? It's not an university, it's not a college, it is not any school, it is not a scientific institution, it is not an institution of research.
Then I may be allowed some time, I will take instruction from you.
15 matter, why?
2 days, lordship, kindly.
How will it matter?
My lord, there has to be a something
this-
in
this-
regular course of business. That is not there, my lord. Regular
This
course of.
actually, they have provided me this notification actually. So private teaching center, that let me ask them.
Oh, see, you cannot go beyond this. And
Yes.
this, whatever is in 1982 is also made part of the scheme.
Yes.
Because this, you see, it's been incorporated. See the footnote, 21st of June 1982. Have you got that scheme which you have just read? This is 46.
Yes, your lordship.
Is it 46?
Published in part 2.
Not 40. This is not 40. This is 96 perhaps. What is C? C means 100, I think. L means 50. Mr. Saraf? C is 100, I think. L is 50. Roman? C is 100, I think.
L is 50.
L is 50. C is 100. This is 96. Insertion 96. And it has also mentioned the number 986 dated 19 February 1982. This one. This
Yes, sir.
notification. And you see the footnote. Footnote, this is inserted in 21st of June 1982. So there cannot be any other interpretation. We have the notification itself. You have placed on record.
Yes, I have put it there. That has been mentioned in, but they did not annex this actually, that.
Doesn't matter, doesn't matter.
I may be allowed 2 days time, Your Lordship.
Day after tomorrow, day after tomorrow, day after tomorrow. Okay.
Not,
Much obliged.
Day
It's
after,
only this jurisdictional issue.
day after tomorrow. I don't think there may be any dispute with this. Okay. Heard Sri B. Boro, learned counsel for the petitioner. Also heard Ms. L. Das Gupta, learned counsel appearing for the Employees Provident Fund Organization. Full stop. The primary ground of challenge is that the activity carried out by the petitioner would not fall under the scheme. Full stop. Though Ms. Dasgupta, the learned counsel, in support of the affidavit in opposition, has placed before this court notification dated, gazette notification dated 19/2/1982, prima facie, it does not appear that the activity carried out by the petitioner would fall under any of the 6 heads. At this stage, the learned counsel for the respondent prays for some accommodation, prays for some time to obtain further instruction. Considering that this writ petition is pending since the year 2015, a day's accommodation is granted and the matter is directed to be listed for hearing on Thursday.
The question whether private tuition center falls under them.
Tuition center, private, public one. Tuition center is not a school. You cannot give a degree or any class.
Well, earlier interim order.
Is there any interim order? Interim order passed today to continue to the next day also. Next. Whole matter.
Well, the issue in fact is covered by division bench judgment. But my submission for lordship is that, that division bench judgment was rendered without considering the earlier Supreme Court decisions. The issue is in fact very short, section.
Yeah, Chaudhary, what do you say?
Lordship, otherwise it is covered by the division bench judgment. And if
So in that case, what recourse does a single judge take?
Well, either your lordship will say that he per incurium or will refer to the division bench.
Per incurium for us to say of a larger bench will not be proper.
No, my lord, that's why I submitted that either it has to be referred to the division bench, thereafter they may consider again that whether it is to be covered.
But you have to cross over the initial hurdle to convince us that the DB is per incurium the Supreme Court.
That I have to, my lord. First of all, I have to show your lordship, that it appears to be per incurium.
But if Mr. Chaudhary is agreeing that a DB has somehow overlooked the Supreme Court judgment, then matters.
That issue I may say, my lord.
Are you agreeing?
no, Lordship, in my humble submission, what I could make out from the division bench judgment, Lordship, the issue raised in the present repetition has been covered.
No, what
Ultimate-
Mr. Dr. Saraf is hinting upon is that while adjudicating the matter by the DB, the so judgment of the Honorable Supreme Court was overlooked.
Yeah, for judgments, my lord.
The judgment on the point. Now, if it is overlooked, then difficult for us to say per incurium, but we can definitely make a reference.
Just say in short, my lord, what is the issue, my lord. My lord, is section 8B was inserted in the Assam Agriculture Income Tax Act with effect from 1/4/2009,
Okay.
levying minimum alternate tax. Now, as you lordship is aware, my lord, whenever the Income Tax Act is amended, then it is amended it will applicable for the year which is consideration. That means assessment year is the next year, this is the previous year. Now, it has been held, my lord, that the amendment which came into force with effect from 1/4/2009 will be applicable in respect of the income of the earlier year.
Now, the Supreme Court in judgments have said, Lord, that it will be applicable in respect of the assessment year of the year.
No, what we understand is the year, financial year in which the law has been incorporated. That year has to be taken to the previous year.
Malo.
And it would come into effect in the next year, which will be the assessment year.
Malo.
Otherwise, it will be given, it will be amount will be retrospective, which is not,
And interestingly, my lord, in the past also,
yes,
number of amendments were made by them.
okay.
Like in sudden relief was also granted to us. That was also given for the next year. Although amendment was made from 1/4/2000 particular
Yes,
year.
yes, assessment year will be the next year.
Otherwise, my lord, what will happen in every amendment which will be made? It will always be retrospective.
Retrospective.
The income has already been generated.
Mm.
And the Supreme Court has said, my lord, it will be from 1st of April, whatever law is there, that will be assessment year. So that is the issue, and this Honorable Court has held, my lord, that it will be applicable for the year 2008-9. So the minimum alternate tax which came into force from 1/4/2009 will be applicable in respect of.
And where is the Honorable Supreme Court judgment?
Well, also.
This 1966 is also one of those.
That is also one
State
of
of Kerala.
Well, Kerala is there, but Supreme Court judgment I'm sure.
This is a 5 judges bench, I think.
Litigation. 96.
Karim Tharavu, Tea
Well, the-
State.
Karim Bhumi Tea State.
Yes. Not Bhumi.
Oh,
Karim
I'm sorry.
Tharuvi.
I'm sorry, my lord. You'll also see para 9, para 8, my lord.
Right.
My lord.
Yes. Also.
Now it is well settled
Yes.
that the Income Tax Act as it stands amended on the first day of April of any financial year must apply to the assessment of that year. Any amendment in the act which came into force after the first day of April financial year would not apply to the assessment of that year, even if the assessment actually made after the amendment came into force. So the 1st April, whenever the amendment is made, my lord, that will be applicable in respect of the financial year, assessment of that financial year. You'll see me again, I read. Of the 1st April of the financial year must apply to the assessment of that year.
Now here the amendment came where?
1st
When?
April 2009.
Okay.
So my submission is that it will be applicable for the assessment of the financial year 2009-10. And that will be the next year the assessment will be done. Assessment year will start from 10-11. So for the current year, starting from 1st April,
Now
this
it
will
is
be
well
applicable.
settled that the Income Tax Act that as it stands amended on the first of any financial year must apply to the assessments of that year.
Well, the division bench proceeded with the assumption, my lord, that since the amendment has been made from 1/4/2009, as such, it will be applicable for the assessment year 2009-10, and thereby the assessment income of 2008-9 will be taxable. Well, 1/4/2009.
Let us again read this.
My lord.
Now it is well settled that the Income Tax Act as it stands amendment on the
1st of April of any financial year, you'll also make note, bro.
as it stands amended on the first day of April of any one must apply to the assessment of that year.
Otherwise, my lord, if you also just look, my lord, in every case it will be retrospective. Like Income Tax Act also, my lord, whenever the amendment is made in budget, it comes into force, it will be applicable in respect of the income which has already been earned.
Here, when was the assessment amendment made?
1/4/2009, lord, from 1/4/2009.
1/4/2009.
My lord.
Let us read the next part of the any amendments in the act which come into force on the first day of April of a financial year would not apply to the assessment. No, any amendments in the after which comes into force after the first day of April of a financial year would not apply to the assessment of that year, even if the assessment is actually made After the amendments.
That means,
came-
my lord, if it comes to from June, like 1st June, then it will not apply to that year. Even if the assessment is made after the amendment.
But here it came on 1st of April.
1st of April, so from financial year starting from 1/4,
Yes,
it will be applicable,
yes.
but not for the year preceding year. For the period from 1/4/2008 to 31st March 2009, it will not be applicable.
Okay, assessments of that year, assessments of that year. Assessments of that. Yes, Mr. Chaudhary.
There are other judgments also, my lord, if you also wants to look into it.
How do you understand this? What is your interpretation in this?
Yes.
Must apply to the assessments of that year.
Lord, again, para 12 of the judgment, or again, we are submitting for also. That will be, I think, may throw some better light, Lord. Para 12. It is well known that the substantive laws to be applied under the determination of the tax liability must be the law which is in force in the relevant assessment year. It is well settled of law to be applied for assessment in the one which is relevant in the assessment year, unless there is an amendment which is made retrospectively, either expressly or by necessary implication.
Please, you're reading 12.
12, my lord.
Please read again.
My lord.
It is well known.
It is well known that the substantive law to be applied for determination of tax liability must be the law which is in force in the relevant assessment year. It is well settled that the law to be applied for assessment is the one which is extant in the assessment year, unless there is an amendment which is made retrospectively either express or by necessary implication. Now, my lord, in my humble submission, my lord, the division bench took it, my lord, that since 1st of April assessment year is there, so the assessment year from 1/4/2009, it will be
1st of April 2009 was the amendment. Okay.
So the court perhaps took into consideration that the assessment year 2009-10 it will be applicable, and thereby the income of 2008-9 will also be taxable. Whereas, my lord, it says, your first judgment says, my lord, on 1st of April of any financial year. So the 1st of April of financial year, it will be applicable in respect of the assessment of that year. Now, in case from 1/4/2009 it is applicable in respect of the income of 2008-9, then whatever amendments are made, it will always be retrospective, which is not permissible. And that is, my lord, in the past also, whenever the amendment they are made from 1/4/2009, but given effect for the next assessment year. Even when they gave the benefit to the petitioners in respect of the export and others, they made it effective from next year. Otherwise, they should have given the benefit also to the assessees for the earlier years.
Yes.
I fully agree with you, Lordship, that to say the division bench judgment per inquirium.
Where is the division bench judgment?
Well, that is. I'm next to it at page 51. Mainly para 5, my lord.
Okay.
Amendments are made in the financial year, and that is applicable in respect of the assessment year, because the income is assessed in the assessment year, but in respect of the previous year. But amendment has to be made in the financial year. Otherwise, it will not give a very, my income has already been earned in 31st March. The budget comes, the rate is increased to 60%. Now the 60% for the earlier year, which has already been passed, that will also become taxable. And if that be so, the state should give all the benefits which the earlier they have not denied, they have denied.
Why was it before a DB initially, this matter?
Well, this was in some other case, my lord.
No, this matter, 7515.
Judgment, my lord, it is your see.
No, 7505. This matter was.
Well, this matter
was initially before the DB.
Initially, I think because at that time, my lord, the DB was taking up the matters.
Okay.
Thereafter, the tax matters were already taken up by DB. But thereafter, my lord, it was shifted.
Yes. You're correct. Yes, Chaudhary.
Well, I think if it is in the FID, if a division bench says that no, my lord, there is correct law, reiterates the law.
Let us do one thing. Let us have this matter sometime later. We'd like to have this.
All other amendments which were made earlier, my lord.
Yes.
That I've given in this petition itself.
No, those we may not.
No, my lord,
We may not be required to go into. We are just.
No, my lord, I was saying, my lord.
Yes.
If my learned friend can also take the instructions whether this was made applicable in respect of the judgments or how it was made applicable, my lord.
Okay.
There are the earlier amendments which were made,
Okay.
whether they were in conformity of the law laid down by the division bench or it was made applicable for the next assessment year.
We'll have some other days.
Yes, ma'am.
Yes, tell us. Third, Dr. Saraf. Itu ulai di pasal ni. Ada extra copy ada. Itu mau boleh boleh.
In fact, I'm not getting a chance of arguing the text matter for what's it. So
So this, if we are agreeing with you, there will be no requirement of further application of mind. She will be remitting pushing the matter to the Honorable Division Bench.
And will not
If we agree with you.
No,
But if
that's correct, Lord. And well, Lord, either there are two courses. Either Lord C dismisses the
Yes.
disposition on the basis of division bench, and I have to go in appeal.
Yes.
Or my Lord, you Lord C.
That is a very easy course of
That is
action.
a very easy course.
Easy course following the division
But
bench.
not in
But if we try to, if we are convinced that there is a requirement for further consideration, then we can.
Then you.
Heard Dr. A. Saraf, London Senior Counsel for the petitioner, as well as B. Chaudhary, London Standing Counsel, Finance and Taxation Department, Para. The London Senior Counsel has submitted that though there is a decision of the Honorable Division Bench of this court, which has been annexed to the writ petition, there it appears that the law laid down by the Honorable Supreme Court
It was not placed also.
were not placed before the Honorable Division Bench, and therefore there is a scope for reconsideration full stop, para. Shri B. Chaudhary, Planning Council, please for some time to examine the issue as well as to take instructions. Full stop, para. Considering the aforesaid situation, the matter is deferred and is directed to be listed for hearing on 28 August.
Right. I'm obliged. No?
In this matter, what happened, my lord? The settlement officer, my lord, converted for Pata land into Sarkai land, my lord, without. My lord, so I'm coming to know about the same, my lord. We submitted an application which is next at one, page 16A.
Patta land was converted to?
Sarkai land.
Okay. Then you submitted an application.
Application, my lord, in 78, my lord, because it appears that it was converted to Sarkai land in 70, my lord. That's the matter. So we came to know and immediately we applied, my lord.
Then?
At page 16A, my lord.
Yes.
I beg to lay that originally I am the owner of the grant number so and so, Gabha Moja, so and so respectively. That in the survey it was found that the lectures are missing and only 179 biga were found in my possession. Now on scrutiny, only 86 biga so and so has been registered in our favor. Some darks of the new lease number so and so, comprising 93 biga 2 katha 3 licha, has been shown Sarkari by mistake in your office. That these 93 biga 2 katha 3 licha are already under plantation. That in support of the above mentioned so and so, I am attached here with the 2 copies of the photo DC so and so so and so. Now, my lord, if your losses comes to page 18, my lord, in this petition itself, my lord, they are and one Assamese also, my lord, that was not translated in the page. Both so and so are sub-deputy city monte, hukum mote, 102 new release grantor 123 dagor, 86 biga mati, bade bari mati so and so 93 biga 2 kotha 8 losa mati sarkari kora hoy. Now, my lord, what happened, my lord? The matter was referred to the government by the letter that the Deputy Commissioner, my lord, at page 18A. My lord, the second para you will also find the settlement officer Nagaon by the order number so and so I declared an area of 93 biga 2 katha 8 licha land as Sarkari from the Kuthari garden under so and so settlement operation. The details of the land so and so declared so and so. My lord, this is what they say. And lastly, my lord, if your losses comes to page 18B, my lord, these last 2 paragraphs, but the said land has already been under possession of the state and management of the garden authorities have been paying for allotment settlement of the said land. The garden authorities have been paying PB revenue regularly. On the other hand, ejection of the tea garden from the possession and uprooting the plants will not serve any purpose as the land in question is surrounded by tea plantation in all sides. Under the above circumstances, the prayer of the tea garden authority for allotment so and so land declared as Sarkari forwarded to you for favor of consideration necessary action. Well, this application letter has been sent to the government, my lord.
Yes, Mr. Goswami,
Yes,
because they had also made an offer
Yes,
that
that in our affidavit that we have explained, my lord. And according to the affidavit, my lord, they have not applied for allotment or settlement of the land. It was, my lord, made sorkari in the year 1970, my lord.
70 years.
55 years back to the from now, my lord.
Yes.
From 15, my lord, it is about 45 years back.
Yes.
And my lord, the source of right under chapter 2 of the regulation, my lord, that has not been explained, my lord. And my lord, above which my respected senior has referred to the my lord, paragraph before that, page 18B. It is therefore certain that measuring 93 bighas, 2 katha, so and so is purely sorkari and the tea garden is encroaching upon the sorkari land. Which he escaped, my lord. So, my lord, it is not that, my lord, he is not encroaching the government land. When he was called upon to cooperate, my lord, for demarcation, that is also he failed to, and thereafter, my
But
lord.
there was an offer in the first order passed by this court.
My,
There was an interim order
my lord.
that demarcation proposed in enforcement case number so and so may be carried out, but the petitioners should not be dispossessed from any
Yes,
tree
yes.
growing land without first considering their offer
Yes.
for giving up equal measure of vacant tea estate land for the proposed move of the government.
Yes.
They are willing to give up an equal
Yes,
without
in our affidavit, my lord, we have categorically stated, my lord, that the land which he has offered to, my lord,
yes, yes.
that is not even cultivable land, not suitable for, my lord, in the midst of the garden, my lord. That cannot be exchanged, my lord. That in our affidavit, we have stated, my lord.
That is not feasible.
Yes, not feasible. And my lord, the part of the now raised the issue of converting the land sorkari without objection, my lord. No such, my lord, his petitioner's obligation, my lord, to submit objection, etc. at the relevant point of time. There is nothing, my lord. So, my lord, present status of the land is out and out. It's a sorkari land, my lord. And according to the instruction received and for the statement made, my lord, for allotment, he has not applied for, my lord. And he has not explained what is the source of his right, which he required to be raised before the authority concerned, my lord, as well as before this honorable court, my lord.
What to do then?
My lord, this is, my lord, what I am submitting, my lord, that the notice was issued for subsequent land, my lord, so far 93 bigha is concerned, that is my land, my lord. Can the settlement officer convert it to a Sarkari land? My lord,
But
on what
your
purpose?
challenge,
Where is this
My lord,
land, my
your
lord?
challenge came very late.
No, sir, we have filed the application in 1978, my lord.
That will not do, my lord.
Where is it?
Yes, my lord, that is the application, first application,
Where?
at page 16A, 1978. We came to know at that point of time. On coming to know, immediately we filed it. It is not that, my lord, today we are filing this.
16?
16A, Annexure 1. That is the application, my lord, the type copy is at page 17, where the note is there.
What is the note?
Note is, my lord, that the settlement officer, as per settlement officer order, 93 bigha has been made Sarkari. What, under what authority settlement officer can do?
The grant of the
And that is why government again asked the Deputy Commissioner, my lord, how it can be made Sarkari, page 21. Page 21 communication may be seen, my lord. That is 91, my lord, because these correspondences are going on. With reference to above, I am directed to say that it seems that a case of restoration of 93 bigha 2 katha 8 lecha of land which Gopal Krishna Tea Estate has purchased in 1963 and has been in continuous possession and under actually T, the circumstance under which the area was made Sarkari are not not clean and not adequately explained in your report. How about a guardian authority may kindly be directed to produce the purchase documents if any in respect of land in question, and then you may submit the same to a government after so and so.
That option also was given to the petitioner, my lord. He has also failed to submit all the required
Documents are there. While
in our affidavit. We have, my lord, categorically stated, my lord, and the application. So he has.
Who will give a fresh consideration? Today, somehow it's not, we'll have a fresh consideration some other day.
My lord.
But not late, it's a old matter.
My lord.
পুরোনো মতো আগত মাতি দেবেন বড় দিকদার হয়ে যায় hearing of 15 or matter was paucity of time did not permit the matter to be taken up in the proper perspective. List for hearing when? Tell us.
September.
On 2nd of September?
Janmashtami nahi hai.
2nd of September? 2nd September. 2nd September.
May remain as part of my lord.
No. 2nd September. We'll finish it up.
I am appearing for this statement.
Okay, liquid. Senate Council and Rigorson Edition Week.
Right.
What is the issue, Mr. Mullah?
The issue is simple, but
If it is a small issue, we'll take, otherwise we'll have it some other day.
report was called for, my lord.
Huh?
That's the thing, record.
What is the, who's for the other side? Be Dr. B.N. Gogoi.
DN Gogoi, he was here just.
Dr. Gogoi was around. It didn't matter. What is the matter?
Matter is, my lord, the petitioner is the customer of UCO Bank, my lord, Zoleshwar branch. In that bank, my lord, in the year 2014, my lord, there was a huge financial scandal, my lord, committed by the bank manager. And thereafter, my lord, the higher officials, my lord, constituted three-man committee for inquiring the matter. And thereafter, the three-man committee, my lord, took individual hearing of all the customers, examined the papers, my lord, and then prepared a summary of claim.
Okay.
And my name is placed in the summary of claim, my lord. Now I am entitled to receive rupees 4,87,000, my lord.
Yes.
Kindly see the page, my lord.
It has not been done.
That
Yes,
is
what
not
do you
the-
say, Dr. Gogoi?
Lordship, I beg to first of all apologize that my pagination is not been done in the affidavit in opposition. Here in this case, your lordship, I have a 10-hour affidavit. Our department bank said that all the documents annexure 1, worksheet claim 168. If lordship permit me annexure 1, although there is no pagination, worksheet of claim SL number 68 after affidavit, your lordship.
Yes. No, is his claim justified? 4,57,000.
The amount which have been said, your lordship, in the computer as well as in the manual, the amount which have been said only 1,000 something, the amount which have been used. That till even point of time, there is the seal which have been used, the amount which have been used is a vague. The amount, the seal signature which have been done, your lordship, with the expert committee said.
If the bank is not agreeing, we cannot pass an order in a writ proceeding.
Lordship.
If actually there is no dispute and some
There is no
reasons.
dispute, my lord. There is, now they are disputing it. There is no dispute on record, my lord. If my lord, seal is different, my lord, they have said in the affair, my lord. Bank higher official, my lord.
What do you do?
Lost
Mr.
affair.
Mr. Mullah, what
My
do
lord,
you
I am a
do?
businessman.
What kind of business?
Businessman, my lord, I have given, we have a statement. Pretty businessman, my lord.
Let us see your the bank statement of that period.
No, my lord, that was manual. Manual when.
The passbook.
Yes, it is there.
Passbook, my lord.
Let us see your passbook.
Passbook, my lord, 11. Page
Page
11.
11.
Page 11, my lord.
Yes. No, not the first page, withdrawal. Not the first page, the other pages. Let's see your passbook.
No, my lord, the case is not of passbook, my lord.
No, we have to see how, what are the modes of your transaction. We will have an idea.
No, my lord, I
You
have
have the passbook with you, is it with you?
no, passbook is not the only first page of the passbook, my lord.
The first page is not there. We want to see the nature of transaction.
It will be found in the annexures, Your Lordship.
Huh?
In my affidavit.
You have filed?
In his affidavit.
Where?
In annexures.
Page?
I declare, Your Lordship, after this worksheet, Your Lordship, if Your Lordship go to annexure 5, these are the transactions, of manual transactions. Photo is also there. Abdul Salam, wife of businessman.
Okay.
The manual, Your Honor.
How do you justify, Mr. Mullah?
No, my lord, case is not here, my lord. Case is, it is a huge, very big case, my lord. 3-man committee, my lord, constituted. A
No,
committee,
you
my-
see the kind of transaction which you are doing.
Yes,
9,000, 2,000, 2,000, 2,000, 1,000.
This is, my lord, later on, my lord, but during the time of manual transaction, my lord.
What is your response to this affidavit position?
And my lord, kindly see now,
What is your reply
my
affidavit?
lord, 3-man committee prepares summary of claim, my lord, page 19, kindly see, my lord.
Then in a writ proceeding, how do you get the relief?
No, my lord, I am entitled because, my lord, kindly see, here what they have done, my lord, kindly see page. 3-man committee was constituted. Now here four members, my lord, have put their signature. They have manufactured this, my lord, subsequently. Kindly see page. Here, my lord, this is.
Now, if the bank was agreeing with you, there's no problem. Now, bank is disagreeing. The number of members in the committee is more important or the bank? Bank is before us.
Now, supposing if I put money, my lord, and some dispute is there, bank says, no, you are not entitled. What will happen, my lord?
No, then you.
Bank is a responsible institution, my
Mr.
lord.
Mullah, you have to at least show us your bank, your passbook. Show us.
No, passbook, my lord.
You show us your passbook that this is the manually which was maintained. This is the passbook. This is the amount which was lying at that time.
That is the case, my lord.
Where is the
Because
passbook?
which amount which I put, my lord, deposited, my lord, that is missing, my lord, and that has been committed by the bank manager.
Where is the passbook?
Passbook, my lord, I will. I have
Bring your
annexed-
passbook.
I have only annexed the
No, that is not enough. Bring your passbook.
account number.
Bring your passbook.
My lord, it is a case of record, my lord. My lord, it is a case of record.
You bring your passbook. First, you have to establish your own case.
No, if there is no money in the passbook, my lord, in the transaction is the problem, my lord. Here,
If you are depositing money
my lord,
and in the passbook it is not up to date,
today,
then what do? You'll sit tight.
my lord, I have given money, my lord, but it is
If you have paid money,
I have paid money.
suppose I pay to my account 1,000 rupees
My lord.
and I give my passbook for updating.
Hmm.
They say there is no money. Will I sit tight?
No, that is the problem.
Then-
I put money, I submit money.
No, let us see the passbook. Where are you shy of? Let us see when it was
In that
updated.
passbook, this amount, my lord, now claimed
Let us
by
see
me,
up till-
there will be no money, my lord.
Let us see up till what date the money.
And that is the case here, my lord.
We want to see the dates of the last updated passbook.
That
There
is-
should not be any difficulty.
But here, my lord, kindly see one thing, my lord.
Mr. Mullah, you have to give the passbook, not the first page,
Page 26, my
not
lord.
the first page.
Can you see page
Get
26?
the passbook.
My lord, let me, for 1 minute, my lord.
20?
My lord, 26, my lord.
Yes.
This is the affidavit filed by the bank
Yes.
in another similar matter, my lord.
Yes.
Paragraph, my lord, 6, my lord. Here, my lord, page 27, but actually designation is not done. Paragraph 6
Yes.
of my, this is the of my petition, my lord. 27, my lord.
Yes.
Paragraph 6, that with regard to the statement made in paragraph 10 of the writ petition, it being matter of facts and records, your deponent denies and disputes anything that is inconsistent with the facts and contrary to the records. It appears that the names of the petitioners in those cases, petitioners never appeared in the said list so of the writ petition as alleged.
In this regard, the deponent states that after receiving the complaint from the customers of Joleshwar branch in respect of anomalies in their SB accounts, the bank had investigated the complaint, and after confirmation of perpetuation of fraud by the staff, Mr. G. Shaha had filed a complaint with the Superintendent of Police, Bureau of Investigation of Economic Offence, Guwahati, against Sri Gautam Shah. Subsequently, the Zonal Office Guwahati constituted a committee comprising of 3 officials to scrutinize all records pertaining to fraud cases of UCO Bank, Joleshwar branch. The said committee conducted hearing independently, wherein all the records were scrutinized and prepared a summary claim with detailed particulars
Yes,
for payment of amount due to the customers.
yes.
It may be mentioned that a total of 330 cases were received, out of which 189 number of cases were found justifiable for payment, and the remaining 141 numbers of cases were not found in order. But my case is within 189. Here, my lord, the names of so and so, my lord, speaking here, my lord, about the petitioners in that cases. Now, the committee having approved and recommended 189 numbers of cases of the customers for payment, forwarded the same to the zonal office for sanctioning the amount to the aggrieved customers. So my name, my lord, has been approved. And
From where do you say?
here, my lord,
No, no,
189.
no, where is your name?
My name is here, my lord, with the affidavit, my lord. Page 30, my lord.
At serial number 8.
8, my lord, Abdul Salam.
This is the list of non-sanctioned claimants. Oh, it comes under 189. How do you say?
I want 189 because they have divided later. The zonal office again scrutinized the records. My lord, after 3-man committee, zonal office, my lord, they have no right, my lord. The zonal office again scrutinized the records, and out of 189 numbers of cases, 146 numbers of cases were approved and forwarded for payment. The remaining 43 numbers of cases are pending for further scrutiny and disposal.
Yes.
So, my lord, this is 3-man committee when, my lord, they have checked up, scrutinized all our records, found, my lord, they satisfied, my lord, and then our name was approved, my lord. And my name here.
But your cases were given for further scrutiny. It is not that all cases. Some
No.
cases were cleared.
3-man committee, my lord. Bank, when after 3-man committee is final, my lord. When committee approved my name, forwarded my
We
name.
cannot accept that submission. Further scrutiny, you cannot be aggrieved. What has happened after the further scrutiny?
Nothing communicated to me, my lord, and it is rejected.
What has happened after this further scrutiny?
Lordship.
It was not rejected per se.
Yes, my lord.
Out of 189, 43 numbers were kept aside, including the present petitioners. How many of you are there? Petitioners?
Here, my lord, I am single.
But this is in respect of somebody else. This affidavit is for whom?
Affidavit is for similar another case. my lord.
2695. No, we want an affidavit in your case.
Yeah, we have filed our affidavit, your lordship. Our main point is in paragraph 6. We have categorically mentioned about what
Paragraph 6.
Yes, lordship.
My lord, it is
Have you finalized thereafter that 43?
that out of 43, my lord, they have given, my lord, serial number 9, then serial number 18, all small, but here big claimants, my lord. The serial number 22, 4-5 lakhs, my lord, 3 lakhs. Then serial number 31, 35 Sultan Ahmed, this is also given by 41. More or less, these are all persons who are having bigger amount. They have been paid, my lord.
As per the documents, your lordship, here in this case, the signatures, verifications, all are doubtful. And as well as the manual and the computerized, it is found that there is a very meager amount. If you see the lordship, the original photo is there also. This photo is also
My lord,
there.
no
It
one
is
can
manual
take
account.
advantage of his own wrong, my lord.
And
They have lost affair. They have admitted that fraud has been committed. My lord, kindly see their affair language, content of the affair. They have lost affair against their own official.
that is a defined part, but so far this
No.
petitioner is concerned, your lordship, we are strictly on our affidavit.
No.
It was a mentioned category in the paragraph number 6, your lordship.
Fatal
And
proposition.
last part in the computerized, it has been mentioned, your lordship. It has been mentioned.
And my lord, here it is sent, recommended for settle, my lord. Kindly see in their affidavit.
Where is your denial, Mr. Mullah, in your reply affidavit? They have stated that you have some 2,000 something rupees.
No, my lord. That is not.
You have
Here-
given a rejoinder. Where is your?
Let me apprise your lordships regarding their affidavit, stand in the affidavit. Then
Yes.
I'm coming. My lord, designation not done. Here I have marked designated, my lord, page 9, my lord, annexure 3. In their affidavit, my lord. See, my lord, how they have corrected it. Once written, again cut. Written, again cut. Page 9, 10, my lord. This is claim, my lord, claim serial number 68. This is, my lord. Annexure 3. Annexure 3, my lord, second page. Here, my lord, serially page 10.
Annexure 3?
Annexure 3.
Yes.
Next page, my lord.
Yes.
Kindly see, rejected. They have cut down it, rejected. Earlier, what was written, my lord, not known.
Where?
Page 10 in their affidavit, my lord.
10 will not do,
My lord.
Annexure 3.
Annexure 3, my lord.
Annexure 3 is page 39. Claim, where is it rejected?
They have cut it, my lord. First rectified. They have written
Not-
what?
Annexure 3 is in the bank format, isn't it?
My lord.
Then which page?
Then next page, my lord.
Next page.
Next page.
Yes, 18/5/2003 account.
Yes, my lord. Yes, my lord. Then rejected. They have cut it down. Claim rejected last. Then, my lord, kind below, last
Yes.
recommendation. As recommended by the committee for raising and verification of claim and as per HO circular so and so, my lord. The claim is recommended to settle.
Where claim is
Below portion, my lord.
from the terminal benefit of this below portion.
Below portion, my lord. Here, my lord, claim is recommended to settle. And my lord, 3-man committee, but here, my lord, they have put signatures of 4 persons, 4 members. Where 4 per worksheet? Kindly see the worksheet of claim serial number 68, annexure 1, my lord. Annexure 1.
Your lordship, annexure 3, prior to that page, your lordship, there is a remark also. If lordship permit me, receipt of this one is there.
Annexure 1, my lord, kindly see 3-man committee, they have said in their affidavit. Now here, my lord, 4 members have put signature. And my lord, manager South Chalmara branch was never a member of 3-man committee.
These counterfoils, the seal are doubtful, Mr. Dr. Gogoi, you are saying?
Yes, lordship. Still, if you lordship permit me, the ink bloated and the old one is completely different, your lordship. If you see the annexure 4, first of all, there is seal, then scratch. And there is a note also, remark.
What is the note? New seal found used.
A new seal found used, which was not used on 10/9/2012 as per the versus 10/9/2012 claim doubtful, deposit of seal not eligible. Verified note initials of GC Saha doubtful. So GC has already been arrested here also.
No, he was the employee who had done the fraud. We are also equally concerned that
bank.
Money of the customers should not be.
Hard-earned money
No,
they have put.
It can be verified by to his bank account, passbook account. His photos are there. If it is Abdul Salam is defined, then it is defined.
What is the period when this amount this misappropriation had taken place?
2012, my lord.
2012.
12. Period was, my lord, 2000.
11/9/2012, your lordship. 10/9/2012 and
11/9/2012.
So that is the period, your lordship, where vouchers have been blotted.
And after 2 years, my lord, when the system was computerized, my lord, then the differential amounts, my lord, has come to light to the customers. After 2 years.
The passbook photocopy which you have given, or rather the statement of account, it is up till 2010.
10.
What happened thereafter?
2013 to 2010, your lordship. Then is account is oversight as
It's being mentioned here. Then thereafter, you'll also, then again, computer is also there.
Where? Okay. Deposits.
We have stated here, Lordship, in our affidavit, in last part, further, if Lordship permit me, annexure 3 and 4, 5, in that page. Computerized, your Lordship, amount is 1194 and manual is 2225, but not 489225, Lordship. It has been mentioned in our affidavit, your Lordship.
And Mr. Mullah, from where do you get this claim of 4 lakh?
4 lakhs, my lord.
That claim which you are making,
My
what is
lord.
the documentary evidence which you
No, my
fall
lord,
upon?
summary of claim, my lord, 19. Page 19, page 20 relevant. Here, my lord, summary of claim, page 19. Particulars for seeking authorization for payment of amounts involved in, my lord. Serial 4, my lord, here, 68 claim number.
Page?
Page, my lord, 20.
20.
20, my lord. Serial 4, my lord.
This is what? This is prepared by whom?
3-man committee, my lord. Below down, my lord, branch manager, then Profullo Bormo, director, RCT Golpara, AK Chaudhary, LDM Kamrup Metro. But in the worksheet, my lord, these signatures, my lord, is different, my lord. First, my lord, four members put their signatures and one is, my lord, absent. And branch manager, my lord, South Salmara, UCO Bank has put signature. He was never a member.
Mr. Dr. Gogoi, your affidavit is shortcoming. This his entire case is based on the averments made in paragraph 6. What is your reply to paragraph 6? You have made a reply at paragraph 5 of your affidavit of opposition. That with regard to the statement made in paragraph 3 to 9, being matters of records, denied and dispute anything which is
Yes, ma'am.
inconsistent. There is no denial.
There is no denial, my lord. And my lord, they have not taken action against me also. Now saying that this is doubtful, that is doubtful, maybe doubtful because of the, my lord, ill doing of their officer. Therefore, they have lost the affair and taken action against the erring official, my lord. If I have done, bank will not leave somebody, my lord, unpunished, to go unpunished, my lord.
We'll consider some other day.
And record, my lord, record is required here, my lord. Because my case is within, my lord, 189 cases, my lord. Record will reveal that, my lord.
You have that details?
I have
But
not.
that affidavit, which was annexed for the other case,
Yes, my lord.
has specifically said that that petitioner was not within the those customers who were cleared. Now, what has happened to him? Same thing. You have not said about Abdul Salam.
We have not said.
In that case, few of the
Have been
I think
accorded.
6 or 7 number of petitioners have said that they needs further scrutiny. You
Lordship.
take instruction. We'll have this sometime later.
Lordship.
Do the heard speak AF and Mullah learned counsel for the petitioner as well as Dr. B. N. Gogoi, learned counsel for the respondent bank. Where do pleadings have been exchanged? Comma, Dr. Gogoi, please for some time to seek further instructions. Full stop. instructions are also required to be taken as to whether the case of the petitioner fell within those customers whose who were required, whose accounts were to be further scrutinized to come to a final conclusion. Full stop. Para. List on, we give a date, old case on 3rd of September. Is it okay, 3rd September?
Not, my lord, record, my lord, I rely on record. If on record I do not get, my lord, I will not submit before your lordship, my lord.
Record they have given the, that will not help you. The computer receipt and the handwritten. Bring those originals, bring those thing.
Lordship.
Then also it will be okay, yes.
Record, no.
The record pertaining to the account of the petitioner may also be obtained by Dr. Gogoi
Lordship.
by the next date. Yes.
My lord, record of the substitute one, record of the, my lord, three-man committee, my lord, recommended my name.
That you have already annexed. That you have annexed.
I have a name.
Yes. Next hour was again.
Obliged, my lord.
Good. Yes, madam, what is this?
May I please go to, Lordship, we need to file reply to the affidavit in opposition sometime maybe granted.
You have filed affidavit, Dr. Gogoi?
Yes, sir, we have filed our affidavit.
Dr. B. N. Gogoi, learned standing on the CDST, has submitted that affidavit in opposition has been filed on 23/20/25. No, not 23, cannot be 23. When did you file?
Lordship on 24/5/2024.
No. That was the petition file.
We have filed on March, Lordship, on the month of March, 23/2025.
23/20/25. But why? It will kill his. But on 12/8, okay. The learned counsel for the petitioner prays for some time to file rejoinder for the list after 2 weeks, along with the rejoinder affidavit that may be filed in the meantime. এখন লোক বসেন।